Judiciary Committee will come to order. Today is Friday, April 24th, 2026, and we have a quorum present. We're going to start out with Senate File 4399, Senator Oumou Verbeten's bill. Senator Wickland, I understand, is going to do the presentation here. So, Senator Wickland, if you want to come forward, this is in your wheelhouse, and we'll get ourselves started with our testimony. Senator Wickland, if you have anyone that you wish to have join you at the testifier table, that's just fine.
Yeah.
And we have particular jurisdiction issues. Okay. So I understand we're going to have a couple of amendments to consider here. All the language in the amendments themselves is judiciary language or issues. So we'll just go ahead. Senator Wickland, welcome to the committee.
Thank you, Mr. Chair. Yes, I appreciate being able to bring forward these amendments. They do include provisions that are related to HHS omnibus bills that haven't been heard in judiciary. So we brought forward two amendments. One is the A4 amendment that includes some of the provisions, and then Senate Council for my committee found some additional items, and that is what, well, it required us to create another amendment. That's the A7 amendment. So I think if you wanted to move the A4 amendment, and then I have Ms. Graham from the Department of Human Services who can talk about kind of what are the areas that are included in this bill, provisions that were brought forward that have judiciary relationship.
Thank you. So this, technically, I think the Senate file is still in your committee, right? Or do we have the actual Senate file? Because our plan, I think, was to lay the bill over, but to vet it for the judiciary issue. So wherever it ends up, finally, we'll be able to add the language that we have adopted. But where is the jacket itself? Do we have it? Yeah, the committee report shows that we actually have the bill.
Yeah.
Okay.
Mr. Chair.
So that's fine. Let's, well, because it's not the
bill.
committee of first jurisdiction, we can't do it as an author's amendment. So.
That's correct. Yeah. It is a bill that is in your committee. Senate File 4399 is one that Senator Oumou Verbeten had brought forward through Human Services and to this committee. So that bill, it is not the first committee stop for this.
Okay. So as a practical matter, let's just put the bill in shape for discussion. Then if members are okay with this, we'll go ahead and Senator Oumou Verbeten will move adoption of the A4 amendment, which is a delete everything amendment.
Mr. Chair.
Senator Kreun.
Before we adopt the amendment, I'm wondering if we could have testimony regarding the amendment. I know there's some people here that would like to testify specifically on the A4.
That'd be fine. Senator Wickland, why don't you, or your testifier, describe the A4 amendment, and then we'll go from there.
Mr. Chair, for the record, my name is Christy Graham, and I'm with the Department of Human Services. Thank you for having us here today. So I'll walk through at a high level the A4 amendment. There are 3 articles in this amendment, the first of which relates to what's referred to as Mental Health Uniform Service Standards, or USS. This is a almost decade-long reform of regulatory structures for mental health services, started back in 2017. It's been a bipartisan effort, and this session, the governor is bringing forward what we call our second phase of this reform, which moves certain mental health medical assistance services from a certification to a more prescribed licensing framework. So those services are adult rehabilitative mental health services, also known as ARMS, certified community behavioral health clinic services, children's therapeutic services and supports, and crisis response services. So in Article 1, the primary changes for these services is adding those services to background study requirements in Chapter 245C. The other change in Article 1 related to those services is identifying that DHS is the lead investigative agency for maltreatment reports. So those are just a couple of clarifications related to a broader reform effort for licensing those services. Article 2 covers background studies for the DHS Office of Inspector General. Section 1 and 7 is related to aligning with FBI requirements, which do not include FBI checks for household members of certain services. So we just need to maintain compliance with those FBI requirements. Section 2 through 6, 8, and 9 are related to making some changes in the background studies chapter so that we have authority to conduct background studies for 4 of our what's referred to as high-risk programs. So those are ARMS, peer recovery services, adult assertive community treatment, and recuperative care. So that is a federal requirement that DHS has to do an enhanced fingerprinting background study that's required in the Code of Federal Regulations for our high-risk services. Moving to Article 3, this is covering our Office of Inspector General, some policy changes. Section 1 is related to providing consumers notices when we subpoena bank records for administrative sanctions. The current process right now is that we have to provide a 180-day notice, I believe, to the courts. And notify the consumer and go through and get a court order to be able to subpoena those records. So this proposal would amend Chapter 13A, Section 03, to allow the commissioner to delay notification to the consumer if doing so would compromise a law enforcement investigation. Section 2 is related to background studies disqualification. So DHS completes background studies as required under law for certain programs, and as part of this, we regularly look at disqualifying crimes and make sure that we're in alignment with Minnesota law and with federal requirements. So this proposal adds a few changes. So it adds the order for protection for financial abuse of a vulnerable adult to the disqualification statute. It adds the new anti-kickback or illegal remunerations crime to the disqualifications. There's a correction related to interference with privacy at the gross misdemeanor level. And then we're correcting the statute that requires the 5-year and 2-year disqualification to apply to family child foster care background studies. Section 3 and Section 11, more background studies cleanup. This is correcting something related to a variance for that it removes language prohibiting a set-aside or a variance for foster care residences and children's residential facilities. Section 4, 12, and 13. This is related to our background studies system. It's called Net Study 2.0. This is a more modernized background study system, and we have a few services that are still in the old system. So we're just, this is language that would allow us to migrate fully over to the new background study system so that those services, child foster care and adult day centers, are still subject to background studies. Section 5 and 6 is related to federal compliance, child foster care transferability clarifications, and child care supervision clarifications. And Mr. Chair, I believe that is the entirety of that particular amendment, and we're happy to answer questions and get more into the weeds with the committee.
Okay, so let's entertain any conversation or discussion about the proposed A4 amendment. Senator Limmer.
Thank you, Mr. Chair. As I'm quickly browsing through the delete everything amendment, perhaps council can tell us what the jurisdiction portions are in this proposal.
Ms. Primo.
Mr. Chair and members, regarding the A4, my understanding is that all these provisions are within the jurisdiction of this committee, and they are from one of the HHS omnibus bills. And because the bill could not be referred here, instead, the provisions were put into this A4, and then there are some additional that maybe we'll get to later in the A7, and is meant to be heard in this committee in this form.
Mr. Chair.
Senator Limmer.
If I can direct your attention to page 10. There's a number of references, lines 10, lines 22, lines 31, where the commissioner will conduct background studies on certain individuals. There's a reference to State Statute 245 in every one of them, I believe, but is there any reference to Chapter 13 regarding these specific investigative reports? And what would be the privacy category that this information would fall into? Is it available for public perusal? Is it private, confidential? Probably not confidential. We're not getting involved in a criminal investigation. But once the commissioner collects and finishes his report, his or her report, can the public look through the same report?
Ms. Grom.
Mr. Chair, Senator Limmer, I'm not certain. I would probably rely on counsel here, but my understanding is this would be public information. By and large, there might be portions that could be protected, but I would defer to counsel.
Ms. Primo.
Mr. Chair and members, 245C is the Department of Human Services background studies statute, and I'm just quickly looking through the chapter, and it looks like there are at least several classifications where the background studies information that's collected pursuant to a study under this chapter is private data on individuals. I, of course, have not had time to dig into each of those, but I believe that those classifications would apply to these provisions as well.
Senator Limmer.
Thank you. I suppose one has to have a discussion, or at least raise the question, how important is this information that may be collected by the commissioner? How important is it to inform the public or not to inform the public on the individuals that the commissioner may be gathering information on? Could you at least give me some idea of that?
Ms. Grom.
Go ahead.
Mr. Chair, Senator Limmer, I mean, these are services that are provided to individuals who may be older adults or what we sometimes refer to as vulnerable adults, children. So, of course, making sure that we've got people that, service providers that can provide those services safely is a paramount interest to the commissioner. It's, a requirement oftentimes at the federal level as well. In terms of informing the public about who these, the backgrounds of these individuals, I guess, if they're not providing the service, I'm not sure that we have if we disqualify them and they aren't providing the service, I'm not sure that we have an interest in providing that information. But I mean, overall, happy to talk through what the protections are in Chapter 13 and if there needs to be changes there. I'm not sure that I understand if you're suggesting a change as it relates to the privacy of these background studies, but happy to hear more from you.
Mr. Chair.
Senator Limmer.
Mr. Chair, I'm not proposing a change. I'm kind of in an investigative role right now, trying to determine, is it important for a report that a commissioner may create, or at least gathering of information regarding these services. Is it important for the public to know the details of the subject? Does it invade any of their privacy, even if it's all good information? I don't know if we've had that real discussion and air that out. I'm just concerned about, and I do believe there's a balance point. There's always a balance point when it comes to privacy regulations. How much does the public need to know versus how much benefit the public receives by such a report when we're overseeing some of these services and the people that may be hired to run that service itself. So I'm just putting it out for discussion.
So, Ms. Grom, the amendment here You're already doing background checks, or the department's already doing background checks in a lot of different categories, right? And so what you're proposing, at least on the portions, page 10 and so on, that Senator Limmer was referring to, you're adding additional categories of providers to the background check system, or you're migrating it to Net Study 2.0. But it's not changing the data classifications for any of the background information that's submitted or analyzed by the department. Is that right?
Mr. Chair, that is correct. We are just, we're not making any changes to how we classify background studies data in this amendment.
Senator Limmer?
No, that's helpful. Thank you.
Senator Holmstrom?
Thank you, Chair Latz. I believe that there was somebody else out in the audience that would like to speak to the data practices concerns on this and testify. Wonder if we could offer them the opportunity.
Well, it's two oblique references to audience members that want to testify. I see Mr. Neumeister is back in committee. Mr. Neumeister, if you'd like to add something to the conversation, come on forward.
Chair Lance and members of the Judiciary Committee, it's great to be back for my first time this year. I want to bring to your attention on the A4 amendment, page 15.
So, Mr. Neumeister, we're on the A7 right now. Did you have anything to add
No,
on the A7?
I apologize. I apologize, Mr. Chairman. I thought it was the A4, my mistake.
We're on the A4.
Oh, I'm sorry. We're on the A4. Did you want to talk on the A4?
That is correct, Mr. Chairman.
Okay, go ahead.
So if you look at Article 3, page 15, lines 23 through 29, and I prepared testimony in that regards. I was here 43 years ago when Chapter 13A was done by your previous folks, and a good person who I worked with for many years was Gene Merriam. He was the chief author of that bill, and so I have a strong interest in this. I rise today with deep concern to strongly oppose the proposed subdivision 2A to Minnesota Statute Section 13A03. This amendment is a dangerous attack on the privacy rights of every Minnesotan. It would let law enforcement secretly seize our financial records, which they do in the process now without knowing. And then there's a process that we eventually know, and then hide the fact from us, potentially for years, without ever needing a court order. All they would have to do is write their own note claiming that notification might compromise the integrity of an investigation. They could renew their own secret delay every 90 days, over and over again, with zero independent oversight or judicial review. And Mr. Chairman and former Chair Lammer, you know how in many situations with search warrants and things like that, that there has been consistent delay, and where the legislature has had to address some of those issues so that the public or the individuals who have that kind of where law enforcement is doing things, they eventually know. Current law, if you look at 13A, wisely requires a neutral judge to decide whether notice can be delayed. That judicial safeguard protects innocent people and prevents government overreach. This proposal rips the judge out of the process entirely, which, if you look at the current 13A, you'll see where a judicial official is very important. It hands law enforcement the power to act as judge, jury, and investigator in their own cases in a way, creating a clear and dangerous conflict of interest. The language is dangerously vague and broad. Almost any ongoing investigation could be used and is an excuse to keep individuals completely in the dark. There is no real limit on how long the secrecy can last, no requirement for detailed justification, and no accountability to any court or oversight body. We, all of us Minnesotans, have a fundamental right to know when the government has taken their most private financial information so they can challenge it if it was done improperly. This amendment destroys that right. Minnesota has long prided itself on strong data privacy protections and government accountability. This amendment in this language, I believe, betrays those values. It erodes our freedoms in different ways, particularly here on the last day when hardly anybody knows about those dynamics. I'm here for other purposes, but I read this bill and that's where I decided to testify. So I encourage to reject this amendment. And Mr. Chairman and members of the committee, I did talk to, as you know, typical Neumeister thing, I approached the people who did this. And I asked, why, this is in an OIG thing. Is this just for the OIG or what? And they were in their own way trying to discuss what, this, that, whatever. So Mr. Chairman, members of the committee, I hope I've been helpful to give you some insight and some dynamics to talk about and to narrow this or to get rid of it and work on it for another time. Thank you, Mr. Chairman, for your time.
Thank you, Mr. Neumeister. So, Senator Wickland, I have been informed that it's possible that it was not your intention to include this particular provision Mr. Neumeister was referring to as your bill moves forward. Is that the case, or help us understand that?
Mr. Chair, Senators, it's one of the policies that was brought forward. We are still working on the program integrity bill, and so I guess I don't have the detailed list of what is going to be included or not in that, but it could be one that we don't include, but I don't have, that bill is a work in progress, so we will have that out this week. If, of course, if the committee decides, this committee decides that it's not, something that should move forward, then, obviously that would affect our ability to include it or not.
Is there, maybe this is a question for council, but under Chapter 13A.03, other than this language that's proposed for a new subdivision 2A, is there any other mechanism for any kind of review or oversight? Or is it entirely proposed to be within the discretion of the investigating law enforcement agency? Ms. Primo, would you be able to answer that? Yeah, we're going to give you a chance to take a look at that. I'm going to note, members, the A7 that's in the packets is intended to amend the A4. So let's consider, if you have questions or testimony about the A7, let's have that conversation together now so that we can, when the time is right, we can add it to the A4 and then adopt the amended A4 to the bill. Ms. Grom, when in your testimony, did you cover the content of the A7 amendment as well?
Yeah.
Ms. Grom, or Senator Wickland, did you cover the A7 content as well, or was it just the A4 content that you've provided testimony on?
Mr. Chair, I just covered the A4.
Okay. So while Ms. Primo is doing her research, why don't you, in response to what Mr. Neumeister testified to, Ms. Grom, if you could go over the content of the A7, and then we'll be able to have a discussion about all of it together.
Yes, Mr. Chair, thank you. So covering the A7 amendment, these are provisions from our Office of Inspector Policy Bill that Senator Wickland carried and was heard in her committee. Section 2 makes changes to Section 245.095. So this is our limits on public funds statute. So we're making some clarifications in this section, defining excluded, and then kind of rearranging some things, adding the credible allegation of fraud in the definition section.
Is that, I'm sorry, Ms. Grom, is that language new to the statute, or are you just relocating it?
Mr. Chair, if you look on page 2, line 24, the credible allegation of fraud is in current law. It's just being moved to the definition section of that statute.
Thank you.
And I believe convicted, if I'm not mistaken, is a new definition in this statute that was not here before, but it is mentioned. The term is mentioned in that section, so we are looking to define it here for clarity. Moving to section 3, this is again making modifications in the same statute. I mentioned moving the credible allegation of fraud to the definition section. And there's also a change in here that expands the department's payment withhold authority. So this would allow us to withhold payment to a provider if they are convicted of a crime involving theft from another state or federal agency, if there is a suspension or revocation of the provider's license, or if there's a background study disqualification under 245C. Section 4 of the amendment is related to licensing, and it clarifies that DHS can immediately act to suspend a license if the license holder or the controlling individual is under administrative, civil, or criminal investigation for fraud. And then Section 16 adds a definition of fraud to Chapter 256B, which is our Medicaid chapter, our medical assistance chapter. So right now, we don't have a definition of fraud in statute. We've got an outdated definition in rule. So this just puts that definition into statute and clarifies what it is, so that we can have increase our ability to make sure that we're sending referrals to the Medicaid fraud control unit and that they've got, you know, the ability to convict or prosecute those crimes.
And Ms. Grom, then if we go to section 2 on page 1, line 30, where it defines fraud, it cross-references the more thorough definition of fraud that you were just referring to on page 6. Is that correct? The new subdivision 20 definition?
Mr. Chair, could you repeat the line number?
If you go back to the first page of the amendment, line 1.30, a new paragraph G defining fraud, it basically adopts and cross-references what you just identified on page 6 as the full definition of fraud. Is that correct?
That's correct, Mr. Chair.
And is that definition of fraud adopted from anywhere else? Or is that new language to a statute?
This is new language to the statute, Mr. Chair. It is similar to the definition in Minnesota rule, but there's some updates to it. For example, I believe this definition of fraud includes illegal remunerations, which was passed last session and heard in this committee. I think that is the main change.
Where is that?
That's on line, page 6, line 13.
All right. The rest of it, you say, is in rule and is being pulled into statute now?
Mr. Chair, that's generally my understanding, but I would need to do a very quick scan of rule to make sure that there isn't anything else new in this section, but it is largely adapted from rule.
All right. Thank you. Please proceed with the rest of the description of the A7.
Thank you, Mr. Chair. All right, and then I think we're on section 17 now. Yes. So section 17 clarifies that a payment withhold is a temporary action and that it's not subject to a contested case hearing, and clarifies that section 15.013 does not apply to DHS for taking action under this section.
How long is that temporary hold? Or how long could it last?
Mr. Chair, my understanding is there is not a defined time limit and that the payment withhold oftentimes is in place until law enforcement completes their investigation. And that could be, it just depends when the Attorney General's office or the FBI or others complete their criminal investigation.
So theoretically, Ms. Grom, that temporary action could occur without any time limitation while a provider is on a payment hold?
Mr. Chair, that is correct. I will say that there has been a lot of discussion on this provision. Last session and this session, we've been working on technical assistance in other bills, and I'm not sure if this will perhaps be a part of Senator Wickland's and whoever else's program integrity bill, but we've been looking at options that would potentially allow an in-camera review of our ability to place a payment withhold based on making sure that we did so under the definition of what a credible allegation of fraud is. So that's language that's being discussed and has been drafted, but hasn't been enacted yet.
Yeah, I'm a bit concerned that a provider would have zero remedy, because you're excluding all of their remedies in this own language, if they felt the payment withhold was unjustified.
Mr. Chair, I hear that. I think that is currently what the status quo is, but happy to work with you and share that language on the in-camera review to get your feedback and the committee's feedback as well.
Well, now would be the time to consider that language, not next week. While it's
We've
in front
provided
of-
that technical assistance to Senator Abler on a different bill that's being worked on behind the scenes that Senator Wickland mentioned.
All right, well, this language is before us because this is our jurisdictional language, so now's the time to consider it. If we're going to do anything, it should happen today.
Mr.
Senator
Chair-
Wickland.
Mr. Chair, that proposal, though, is being brought forward through a member who is working on it. I can't speak to, how, if he wants to get it through. There's been a lot of negotiation about the language, and so there's still work going on to make sure that, that can come up with something that would satisfy both DHS and the people subject to withholds. So that is separate from what we're doing here. It's not a part of DHS's official proposals, so that's why you don't see it in here.
No, I understand that, but this bill is in front of us to consider and to adopt as a template then to go forward in the DHS in your larger package, right? So if this committee is going to give its approval or imprimatur to language, it should be the language that we think it ought to be in permanently, not just subject to some further review in a different committee somewhere else. So, our plan is to lay this over anyway, but we're not planning to meet after today. So
understand that.
today is the time, and we don't like to defer to others the stuff that this committee is the one that should be in charge of. Just like we are very meticulous in not encroaching on other committees' jurisdiction. Senator Wickland, how do you propose we proceed?
Well, I think it is definitely an open question. This due process issue has been something that we have been talking about with multiple stakeholders all session. I haven't been working on it as much, but there are senators who have been working on it closely with advocates. And it's not, I guess I understand that you can only evaluate what is before you. But I don't have that other language to bring to you today, and it isn't my language. So I guess I'm not sure how else to proceed except that to evaluate what we have before us. If there is additional collaboration that is done and they come up with other language, then we will have to discuss with you how that would be evaluated, because I understand this is the last hearing, so. And I think it's, the reason that it's taken us a long time is that it is a very complex issue. This language is complex, the existing language is complex, and making changes to it is challenging. So it's just taken a lot of discussion.
So I respect that it's a challenging thing to do, but we're 3 weeks from the end of the legislative session, and this is our committee's jurisdiction. And maybe I'm the only one who's concerned about this, but if the committee's will is that we need additional language to address this question, then it's not going to be done unless it comes back with language before we're done with our committee hearing today. So, all right, so we have at least put a pin in that issue as well. Ms. Primo, have you had a chance to review the earlier question about back on the A4 amendment, page 15, Article 3, Section 1 relating to law enforcement delaying notification?
Mr. Chair,
Ms.
yes.
Primo.
I think the question that you had posed was whether there's any continued oversight related to the discretion that law enforcement has will be given if this were enacted. And I think the answer to that is no. Under current law, the notification can be delayed, but with a court order. This would act as an exemption to that, and it would be law enforcement who solely makes a determination that the notification would compromise the integrity of a current and ongoing criminal investigation, and they would provide that to the financial institution. And under Chapter 13A, the financial institution is required to comply with orders that they receive from law enforcement pursuant to this chapter. It's possible a customer could attempt to challenge it, but the customer would not have the appropriate notification. That is essentially the point of this exception. So I'm not sure how a person would be able to challenge the discretion that's given to law enforcement.
So, Ms. Primo, maybe I need a little more clarity on this. So the notification that's contemplated here to a customer, who's the customer? I guess that's the, who would not, you're saying it's a financial institution that would be getting notification or not? Ms. Primo?
Mr. Chair and members, customer is defined in the chapter. It means any natural person or authorized representative of that person who utilizes the services of the financial institution or for whom the financial institution is acting as a fiduciary. So it's the person who owns that account with the financial institution.
So essentially the provider in the cases here?
Yeah.
Senator Wickler?
Mr. Chair, it could be individuals or providers, yes, but
Okay.
people who
So
are.
obviously you don't want to compromise the investigation by telling the subject of the investigation that they're being investigated.
That's correct.
Because you want to make sure you can get all the information you need before they catch on, cover up, delete, destroy, or change behavior before you've got enough information to identify what's going on. Am I understanding that point, that correctly, Senator Wickland?
Mr. Chair, yes.
Okay. But these investigations can take years, I would assume. Am I mistaken in that, or?
Mr. Chair,
Ms. Grum?
that may be possible. I would probably defer to our law enforcement partners, but it could be years.
Right, I mean, some of it's a function of resources, especially if there are a lot of other investigations that are going on at the same time. So the investigation might be happening, but this wouldn't necessarily be cutting off funds right away, which was sort of a different situation. It would be, the provider would continue providing their services, presumably. They just wouldn't know they're being investigated. Is that the idea? Ms. Grom?
Mr. Chair, yes, that may be the case. This does not, there are times when we work with law enforcement to not impose a payment withhold, for example, for the same reason, because it may tip off the, it may compromise the investigation.
Mr. Newmeyer, did you want to add something here? You seem anxious to do so. Come on forward.
Just a clarification. Mr. Chairman, members of the committee, a very big clarification. This involves any law enforcement investigation with any kind of money involved. This is not just for a DHS fraud investigation. It's with any law enforcement, that any individual where a law enforcement entity on any investigation involving some type of money, whatever, where they need financial, could continuously delay notice. So Mr. Chairman and the committee, I just wanted to clarify, this is bigger, and that's where, Mr. Chairman, when I went and I discussed with the representatives of DHS who are pushing this, then they were even themselves announced, is this just for OIG type things, or is it broadly? So Mr. Chairman, that's my clarification. I hope that's helpful to you.
Mr. Neumeister, do you have any suggestions how to put language in that would balance this? I mean, obviously, you don't want to tip off a subject of an investigation and give them the opportunity to destroy evidence or anything like that. On the other hand, at some point, it's appropriate for them to find out they're being investigated. Mr. Neumeister?
Mr. Chairman, members of the committee, I go back to an old axiom I learned decades ago. What's the problem and what are you trying to fix? In other words, are we coming in with a proposal that's very broad and can hurt privacy rights of individuals? So it's important to be more focused on what the problem is. If it's an issue because it takes years for fraud investigations in DHS, let's have a specific thing to that, rather than a broad kind of dynamic that we have here. So I'm just trying to encourage to try that limit to it.
Because today, it says today.
Mr. Chairman, members of the committee, I
Mr.
thank you
Neumeister?
for that opportunity.
Yeah, thank you for that.
That must be within DHS.
So Chapter 13A is specifically related to law enforcement investigations and financial institutions, as I understand. But it is broad. Doesn't apply just to Medicaid fraud investigations, for example, or DHS investigations. It'd be changing the statute for every investigation. I think that's a fair consideration. Now, theoretically, we could narrow any new language just to DHS investigations. Some of the same issues would be raised, though, in terms of at what point should a subject of an investigation be made aware or be entitled to know that they're under investigation, and at whose discretion ultimately then should that take place. All right, well, I'm raising some questions. I'm not sure I've heard any kind of a limiting principle proposed here. Senator Limmer, to that point. Senator Holmstrom, you're on our list, but to this point.
I'm happy to defer to.
Okay, Senator Limmer.
Thank you, Mr. Chair. I'm trying to better understand the application of what we're talking about on page 15 of the A4. The delay notification to a customer without a court order. If there was a court order, would the subject have any, would they receive any information that there's an investigation ongoing? And the other question would be is, I would hate to have this pass and then, based on a court hearing, a defense attorney raise for dismissal because there would be a violation of the Fourth Amendment on an improper search without a warrant. I don't know if that's a legitimate concern, but with my limited knowledge, it might be. I don't know if council can give any insight to that. I'm very concerned that the government is doing any type of investigation without a court order or a warrant.
Well, Senator Limmer, law enforcement agencies investigate all the time without getting a warrant unless there's some specific information that they need from the subject of the investigation that they would need a warrant to obtain, or from others, that's information in the hands of some other organization that they would need a warrant for. But the initial investigation, there are subpoenas. Some agencies have subpoena power. They don't need to go get warrants. We've had that conversation here in this committee recently. But I share your concern. I'm also concerned about, if an investigation takes 2 years, and this has come up in this recent context. Meanwhile, the investigation's going on, but money is still going out the door, maybe fraudulently being obtained by a provider, and then at some point you end up with charges and you're 2 years down the road, and what started out as a comparatively small amount has now mushroomed 2 years into provider payments that were improperly obtained. And that's taxpayer money that might not be recoverable. So at what point do you strike a balance? Do you say, you can do this, has to be renewed every 90 days, but after 180 days, it needs judicial review to continue? Or is there some other language in here that's some limiting principle? We wouldn't want to compromise investigations. On the other hand, at some point, process needs to be fair to the subject of the investigation as well. Senator Lerner.
Doesn't law enforcement face that same difficulty, let's say, with an ongoing drug investigation where they're tracking trafficking of drugs and illicit material, and it takes time to build a case, and in the process of the time factor, the threat is still out in the community, and so they deal with that all the time. And I would imagine this would probably not be any different. I'm just concerned that government would be working without a court order. I would imagine if this is bank records and other documents, behaviors, this seems like it could be overly broad by not specifics being referenced. And that certainly would happen without a court order. So I think it does raise serious civil liberty questions.
Ms. Primo.
Mr. Chair and members, I'm just going to provide a little overview of how this works under current law. So the chapter is 13A, and it governs all government entity access to financial institution records. So under 13A.02, subdivision 1, the government entity may currently access financial records with the customer's consent, pursuant to a search warrant, pursuant to a judicial or administrative subpoena, as well as some other provisions. And then under current law, within 180 days after the government entity obtains access to those records, that is when they are required to notify the customer, the person who owns that financial account, about this access. Under current law as well, if the law enforcement entity or government entity would like to delay that 180-day notification, they would then go to court to get a court order at that point to delay that notification to the customer. And what this subdivision on page 15 is trying to do is to exempt the law enforcement agency from going to court to get that delay of notification order, and instead continue to delay notification to the customer as they continue their investigation.
So, Ms. Primo, this proposal would eliminate judicial oversight with regard to whether or not to provide that notification, and it would also then save the investigating agency the time and effort and resources necessary to go obtain that extension from a judge. Is that accurate, Ms. Primo?
Mr. Chair, yes.
Okay, so then the question comes back to what is the need for this exception? Ms. Grom?
Mr. Chair, my understanding is consistent with the way you described it. It's to help law enforcement expedite, save resources, get, investigate quicker than they currently are allowed to, or able to.
I'm not following the investigate quicker part. The difference is whether or not they're required to go present their justification for not notifying the customer to a judge to get that exception authorized. The
Mr.
investigation would continue. Ms. Grom?
Yeah, Mr. Chair, I need to look at the statute again to make sure I understand the 180 days, but my understanding was, initially, was that this would allow us to waive the 180-day timeline.
And
Maybe.
I understand that to be the case. I'm trying to figure out why. Other than saving the resources of going to get a judge to say it's okay.
If they're able to do that, and they would prolong the length of time, the person doesn't know about it.
Yeah.
Mr. Chair,
Senator
would,
Wickland.
would this give them the ability to lengthen the process before which a person is notified or becomes aware of the investigation happening or the request happening to subpoena or to get access to those records, financial records?
So Senator Wickland, what I understand to be the case from Ms. Primo is that they can get the records from the financial institution now with a court order or a subpoena or a warrant without the customer of the financial institution being notified that the records were obtained. The question is, when does the customer become aware that the investigation is going on? And it looks like the purpose of this proposed provision is so that law enforcement can do it on their own rather than having to go in and get a court to say it's okay to continue without notifying the customer.
Mr. Chair,
Ms. Grom.
maybe just to clarify, I think my understanding is maybe investigating quicker was not the right phraseology. It was more so as to not compromise the investigation. So maybe make sure that the investigation is more effective.
Ms. Grom, would the investigation be compromised if the investigating agency went into court to get an order saying they can continue investigating without notifying the customer, other than the resources involved in getting that court order? I don't see how the investigation itself would be compromised unless a court disagreed with the law enforcement agency's conclusion about compromising the investigation. But that's why we have judicial oversight too.
Yeah. Mr. Chair, I think you raise a valid point.
Mr.
Senator
Chair.
Holmstrom.
In response to that, I agree that there should be judicial overview on these things. I would make an amendment that we remove, let's see, this whole section. So the amendment would be to, on page 15, line 23 to 15, line 25, remove those, or sorry, 29. Let me look at it again. So page 15, lines 25 through 29, remove them entirely. Subdivision 2A.
I'm sorry, would you please, I was consulting with counsel during part of your comment there, Senator Holmstrom. Could you repeat that, please?
Yes, so the amendment would be on page 15, remove lines 25 through 29. Sorry.
So you want to delete
23.
section 1?
Section 1, correct.
Okay, so Senator Holmstrom moves to amend the A4 amendment to delete Article 3, Section 1. So let's have any further conversation or discussion Senator Wickland, what's your position on the proposed amendment?
Mr. Chair, I think that seems like the most prudent thing. Realizing now that this affects, you know, a broader universe than DHS investigations and could affect, you know, other types of investigations, I guess it seems prudent to set this aside and have more discussion because of that impact on, you know, larger than DHS. So I'm fine with that, removing that.
Any further discussion on Senator Holmstrom's motion? I'm not seeing any. All in favor, say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further discussion on the A7 or the A4 amendments? I think we do need to I would like anyway to go back to the question on page 7 in section 17 of the A7 relating to not allowing review of the withholding of payments determination. On the A7 amendment, page 7, lines 31 and 32, the proposed new language stating that the withholding of payments is temporary and not subject to review, basically. Is there anyone else on the committee that shares the concern, or am I just standing alone on this one? Senator Holmstrom.
Thank you, Chair Latz. I actually deeply agree with you on this. We saw withholding of payments to autism centers earlier this year, and some of those may have been legitimate, but I will point out that DHS withheld payments for a prepayment review process. That resulted in 2 autism care centers in outstate Minnesota closing, and they ended up not withholding payments from any providers at all. So nobody actually lost payments. They all just got withheld long enough that they couldn't pay their rent, had to close down, and there was no fraud detected in their prepayment review. So they caused all this pain to legitimate centers, and I went and met with several of them. One had to cash out her retirement account to cover rent on these buildings, and significant cost to her to keep her basically nonprofit alive. And again, the result was DHS didn't find or expose any fraudulent centers in that. And we know that fraudulent centers exist. This tool just wasn't effective for them to get to the bottom of it, but it caused significant harm across the industry. So I would very much so contest this.
So this is a balancing act, right? We want to make sure that DHS has the tools to immediately stop the outflow of money to a fraudulent provider, but we also don't want them to unnecessarily harm the providers that are not fraudulently obtaining the funds. And the question is, how do we make sure there's sufficient tools available and restraint on those tools?
Yes, Chair Latz, that's my primary concern. And I would say that there's got to be some way that a program could contest it. There's got to be some judicial oversight or some way to come before a board and explain whatever the discrepancy is so that they can collect payment on their services.
So I'm interested in any language proposals to address that concern. And if we don't have any language at our fingertips at the moment, I will simply say we are going to be here in committee for at least several more hours. And I'd like us to address this topic before we're done with this bill here today. I'm sure that's not what anyone else advocating for the bill wants to hear, because no one else wants to be here on Judiciary Fridays except the members of the Judiciary Committee. I'm making assumptions here, too. Senator Wickland.
Mr. Chair, I will be here all day too because I'm on the Finance Committee, so I'm not excluded from Friday fun committees, so. I would be happy to go back to, my staff, my team that's working on the program integrity bill to have more, to get a better sense from them whether the language that Ms. Graham mentioned that we've been discussing about this really thorny issue of how do you balance having the tools to be able to stop payments in a way that prevents us from seeing fraudulent, actions affecting our budget, balancing that with the rights of people to, to know more about the timeline for this investigation work. So I would be happy to do more research. I could come back with kind of summary of where we're at. I really don't think I will have like the language that we'd like to propose to. Oh, I'm being told there is some language, but Ms. Graham, I don't know if you want to comment on that.
Ms. Graham.
Mr. Chair, there is draft language that I believe Senate Council has worked on that we could work with council and share that language today. I do want to make sure the committee is aware that this is not actually a change to our current process. This is a clarification in a new statute, chapter, it's referring to chapter 13, I think. Currently, we don't have a contested case hearing right. There is in section 245.095 an allowance for a provider to, when we do impose a payment withhold, to do an administrative reconsideration. So that's the current allowance in law, but there's currently not a right to a contested case hearing. Just wanted to clarify that for you, but we've heard the concerns similar to what you've expressed today, and I'm happy to provide the draft language that's in process at the moment.
So let me see if there's discussion on any of the other proposed terms of the A4 or the A7 amendment before we move on with the conversation. Okay, so see, I want to make sure we get this right procedurally. So I'm going to suggest then that we hold off on adopting. Well, wait, right. So we don't, right now, we're not in a position to move the A7 because that's not ready, which would be to the A4, which means neither of them would be ready at the moment. But we do have at least one other amendment in the pack, two other amendments in the pack, an A5 and an A6 that we can consider independently. So we're going to set aside the A4 and A7 for now while we work on that provision in section 17 of the A7. And then we're going to bring before us the A6 amendment of Senator Duckworth, who is present. Senator Duckworth, we have before us for consideration the A6 amendment. Welcome to the committee, by the way, and why don't you go ahead and explain what you would like us to do here.
Will do, Mr. Chair. Thank you. So the A6 amendment is also reflective of Senate File 4652, which has had some hearings and been before members before, just in the Commerce Committee. This bill is referred to as a trusted contact program, specifically for folks in their bank accounts to help combat fraud and allow banks to alert folks if and when they maybe suspect fraud. I think specific to this committee, they're most interested in subdivision 5 of the amendment, which is certain liability limited, and I will let our testifiers speak to that if that's okay with you, Mr. Chair.
That's just fine, Senator Duckworth. You Tess Rice.
Thank you.
Welcome to
Mr. Chair.
committee. Go
Thank
ahead and
you.
introduce yourself and give us your testimony, please.
Mr. Chair, committee members, my name is Tess Rice. I'm General Counsel for the Minnesota Bankers Association. This is our bill. It's modeled on language from Missouri that's also been adopted in Kansas. It's a fraud prevention tool. And would you like me to just run through the liability
Yes,
provisions?
please. Yeah, just the part that we're
Yeah.
attending to.
Sure. So subdivision 5, the first sentence, a financial services provider, so this includes credit unions, are not liable for actions of the trusted contact. A trusted contact is the person appointed by the bank customer to get information about the account. So that's pretty simple, I guess. And then the next one is a bank is not liable if it has a good faith belief that a trusted contact is not acting in the customer's best interest. So if a customer appoints, let's say, a family member as a trusted contact, but then the bank has a reasonable suspicion that person is involved in some fraud, the bank would not be liable if it did not contact that trusted contact. Next, the bank is not civilly liable for reporting to law enforcement. We don't have that protection currently in 13A. So I thought it would be good to put in here. And then next, the bank is not civilly liable for implementing or not implementing a program. It was a big deal to us to make this voluntary. Some banks are doing this already, but we'd really like to bring community banks into this, but they are nervous about possible liability. And then after that, they're not liable for actions or omissions in administering the program. So there's always gray areas, especially with fraud, where you're just not sure if it's fraud. It might be. And so an action, a bank might do would be contacting the trusted contact, or an omission would be not contacting that third party because they weren't sure it was fraud. It didn't seem to rise to the level where they would contact the third party. Deciding whether to share info would be an action. And so there's just different little choices that are made along the way in fraud situations, and we're trying to protect them from civil liability if they act with reasonable care and in good faith. And finally, the trusted contact who acts in good faith and exercises reasonable care, so that's the person that was appointed by the customer, is immune from liability. So that's meant to encourage their participation in the program.
Thank you. Are there any questions from members of the committee on the proposed A6 amendment? All right. Sorry. Senator Limmer.
Thank you, Mr. Chair. I noticed on page 1, line 17, there's the clause begins notwithstanding any other law. Could that create a conflict with anything else we may have in our statutes?
Mr. Chair, committee members, or Senator Limmer, I don't know of any conflict in there. This was modeled on Missouri, though, so I think, I didn't change anything if I didn't have to. So, no, I'm not aware of anything in current law that this would conflict with.
Okay.
Senator Limmer.
Thank you, Mr. Chair. I'm sure the people in Missouri did their work as properly as they could. I don't necessarily take the work of another state that casually. And so I just raised the question because every time I see a notwithstanding, it should be focused on and addressed. But nevertheless, I don't know if council has any opinion on it. But
Ms. Primo.
Mr. Chair and members, it's likely that we don't need that beginning phrase. I'm not aware of a specific statute, and this language would stand on its own in terms of it being its own authority to allow the financial services provider to act in accordance with this new section of law.
Senator Limmer.
Hearing that, Mr. Chair, I would move to amend on line 117, perhaps council can create or suggest the amendment, but the spirit of it would be to take out the notwithstanding provision, perhaps just remove the language after the A parentheses on line 17 and start the sentence fresh with lines 18.
Senator Lemmer, we can have council describe the amendment, but she's identified language that's similar or identical with that in a few other locations on this bill. Ms. Primo?
Okay.
Mr. Chair and members, that same clause appears at line 1.13, 1.17, and 1.32. So the amendment would be page 1, line 13, delete notwithstanding any, page 1, line 14, delete other law to the contrary, comma, page 1, line 17, delete notwithstanding any other law to the contrary, comma, page 1, line 32, delete notwithstanding any other law to the contrary, comma.
Senator Lemmer so moves.
So moved, Mr. Chair.
Any further discussion? Not seeing any. All in favor, say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Any further discussion on the A6 amendment as amended? Not seeing any. Senator Oumou Verbeten moves adoption of the A6 amendment as amended. All those in favor say aye.
Aye.
Opposed? Motion prevails. It's adopted. All right, Senator Duckworth, I think that takes care of your A6 amendment.
Notwithstanding any further comment? Thank you, Mr. Chair.
Thank you, Senator Duckworth. So the next stop here would be the A5 amendment. Okay, it looks like we got a couple of Department of Commerce testifiers to come forward on the A5. Let's see who comes forward. The Department of Health. I've identified the state health economist as well. Whoever wants to testify on the A5 amendment, we have 3 chairs up there. Come on forward. Who wants to start? Go ahead and identify yourself.
Good morning, Chair Latz, members of the committee. My name is PJ Mitchell. I'm the Director of Regulatory and Health Policy Strategy at the Department of Commerce. By way of background, the governor's supplemental budget includes a proposal to transition the regulatory oversight of HMOs and county-based purchasers from the Department of Health to the Department of Commerce. This bill has been heard in Senate Commerce and Health committees. And as part of that proposal, there are several provisions, those in front of the committee today, that authorize data sharing capabilities between state agencies to reflect the transition of HMOs from MDH to Commerce and to strengthen oversight in Minnesota's health insurance markets. I'm happy to do a high-level walkthrough of the sections if that's helpful. Otherwise, happy to take questions from the committee.
These are all data provisions, so they're all within our jurisdiction. Could you take us through each section, please?
Chair Latz, happy to do that.
Mr. Mitchell.
So Section 1 pertains to HMO and county-based purchaser annual reporting under Section 62D08 that is currently submitted to the Department of Health, but would be submitted to Commerce under the HMO oversight proposal. The language in Section 1 would require Commerce to share non-public data from the required reports with the Department of Health, Department of Human Services, and other state and federal entities that request that data, provided the recipients maintain the data's original classification. The section also allows Commerce to enter into agreements when sharing this data. For Section 2, while the regulatory authority over HMOs is moving from MDH to Commerce, both agencies are committed to ensuring a continued role for MDH in monitoring the overall insurance market and to coordinate work on policy solutions to address challenges to market stability. So in light of that transfer of the regulatory oversight responsibilities, the language in Section 2 clarifies the data sharing authority between state agencies to support obligations by ensuring MDH access to non-public data necessary for market oversight, analysis, reporting, and policy development. The language also clarifies access to non-public data that MDH currently has access to and ensures that it maintains non-public classification, that data remain aggregated and identified in any proposal or in any public report, and the proposal also authorizes other agencies to charge fees for custom data sets. Section 3 authorizes data sharing between MDH and Commerce related to prescription drug pricing data reported by health plans. Currently, Commerce receives this data and is required to consult with the Department of Health to release a summary of the data. This would allow us to share the data with health as well. And then sections 4 and 5 authorize data sharing between the Minnesota Department of Health and Commerce for data reported by pharmacy benefit managers on the cost of prescription drugs and rebate practices under 62W06, as well as on healthcare claims in Minnesota reported under 62U.04. This proposal aims to enable more efficient data-driven results for both agencies by improving the analytics that each agency can produce, particularly transition in light of that transition of regulatory oversight from MDH to Commerce.
And then section 5?
Apologies. Section 5 is related to 62U04. Sorry, I bunched section 4 and 5 together.
Okay.
Apologies.
Thank you. And then, are you Mr. Gildemeister? Are you here to answer questions or to offer additional testimony?
Mr. Chair, members of the committee, Stefan Gildemeister, I direct the Health Economics Program in the Department of Health. And as much as I'd like to contribute, I really have nothing to add to the previous presentation, but I'm happy to take questions if that's helpful.
Thank you for being available for that. Any members of the committee? Oh, we have a technical amendment here. By the way, Senator Oumou Verbeten would move to adopt the amendment as follows on lines 2.8 and 2.10. Delete the words "of commerce." So this is suggested language from council, as I understand, right? Oh, from the departments. So just referring to the commissioner. Oh, just because we don't need to say "of commerce" twice? Ms. Primo? Maybe we can get a clarification.
Yeah, Chair Latz, members of the
Mr.
committee,
Mitchell.
this is a technical correction. This is actually intended to be the Commissioner of Health, and the phrase "of commerce" was included. So by removing "of commerce," it clarifies that that statement applies to the Commissioner of Health.
Got it. Let's move by Senator Oumou Verbeten. All those in favor say aye. Oh, Senator Limmer.
Just one last question. The information that's listed in this amendment, is it limited to aggregate or summary data, or is it more specific?
Mr. Mitchell? Mr. Gildemeister?
Chair Latz, Senator Limmer, generally this information is, it's at a claims level. In some cases, that information is aggregated up, but the data, may differ based on what's being reported. I defer to my colleague at Health to provide any additional information on that level of data.
Mr. Gildemeister?
Mr. Chair and Senator, just to reiterate the previous comment, 62J40 is a Department of Health statute, so the correction here clarifies that the commissioner who may request information is the Commissioner of Health, which under which this statute is governed. I think the language is fairly broad and could include data that are non-public. But I think there is a reference under subdivision E that clarifies that Minnesota's data practices statute comes into effect here. So while access to the data may be available to the Commission of Health, nothing in the classification or the protection really changes.
Thank you.
Any further discussion? Not seeing any, so Senator Oumou Verbeten is going to offer the A5 amendment as she is amending on lines 2.8 and 2.9-10 to delete the words "of commerce" in each location. All those in favor say aye. Aye. Opposed? Motion prevails. The A5 as amended is adopted. All right, so now we're back on the underlying bill, which we are going to lay on the table until we get more feedback from Senator Wickland with regard to the language we were discussing earlier. We will return to that Senate file as the last item on our agenda so that we can address those concerns. Members, the next item we're going to address is Senator Kreun, Senate File 730. So Senator Kreun, if you wish to go to the testifier table and you can describe your bill to the committee. And members, the bill and other Senate Council description and so on in the bill packet are being distributed to the committee members. That includes a memo from Senate Council, research and fiscal analysis, and a letter from the Attorney General's office, as well as the bill itself. Senator Kreun, whenever you're ready.
Thank you, Mr. Chair, members of the committee. Senate File 730 was heard last year at the beginning of session during the brief power sharing arrangement that we had. I believe we laid 730 on the table. I don't know if there needs to be a motion to take it off the table, but I'll proceed with my testimony and somebody can correct me or let me know if that needs to happen.
No, we have it before the committee. We've taken it off the table.
Thank you, Mr. Chair.
And,
All right,
and just so you know, Senator Kreun, at some point when you're done, we're going to ask Ms. Primo to give us sort of the underlying context of the bill again, since some of us don't remember back to January 2025 quite as well as you might.
Mr. Chair, I was going to give a truncated version of that in my presentation, but I'd be happy if Ms. Primo would like to supplement that, as I'm sure she would be much more thorough than I would be.
Would you like to go ahead first?
Yes, Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. This bill clarifies that Section 1365, Subdivision 1 may be withheld from the public only when the data pertains to individuals. When the legislature uses the term private data on individuals, it must pertain to individuals. That's how the Attorney General's office had been operating for over 40 years. The Minnesota Supreme Court case of Energy Policy Advocates versus Ellison changed that. The majority opinion came to a rather curious conclusion that the legislature used the word individuals in Section 1365 to cover data that was not on individuals. My bill's not getting to anything else. I've not been partisan on this bill. I'm just trying to correct what I think was an improper decision by the Minnesota Supreme Court. This bill does not mean that data on corporations or non-individual entities automatically becomes public. If another privacy classification exists, it will still be protected. It does not change the attorney-client privilege. It does not allow access for information subject to open investigations. It does not mean that data on corporations or non-individuals automatically become public. If there's another classification, like I said, it'll still be protected and keep that data confidential. So the note from the Attorney General last year, given the current state with the Minnesota Supreme Court decision that it is, large swaths of data are not being available to the public when they're not on individuals. I presented some examples last year of why this is concerning. I won't go over those this time in the interest of time. but
Well, Senator Kreun, we do intend to take action on the bill today, so if you
Okay.
think it'd be helpful for us to
Very
know, then go ahead.
thank you, Mr. Chair. One of the examples, and we heard from testimony that it's large swaths across all categories, but what I keyed in on is if the Attorney General's office accepted money from an outside interest group to litigate a case, that information should have become public at some point to know whether or not that interest group is guiding policy within the Attorney General's office. And if taxpayer dollars were directed to the Attorney General's office to influence the office to do something or not to do something or on some policy, that would be something that the public would have a right to know. These are questions that the people of Minnesota have a right to have answers to, and we shouldn't have to speculate. This bill here, Senate File 730, would bring back the Attorney General's office in line with the rules that the rest of the executive branch already are subject to. So it'd bring it consistent with the rest of the executive branch rather than give the Attorney General's office a different standard to keep more data private. Since the hearing that we had last year on this, Mr. Chair, as you know, I believe, and I'm not speaking for, I think the committee recognized there is some issue here. And so, Mr. Chair, you sent Senator Clark and myself to see if we could negotiate something with the Attorney General's office. That meeting was not productive, and the Attorney General did not want to work with us on coming up for a solution on this bill and simply said that he would oppose the bill. So here we are.
Senator Kreun,
Yep.
I'd like to keep this
Yep.
conversation focused on the merits of the proposal itself rather than characterizing other parties to discussions or negotiations, please.
Thank you, Mr. Chair, just bringing this committee up to speed. But anyway, I
Well-
strongly agree with former Speaker and now Justice Thiessen in his dissent in that case, that the plain language of the existing statute makes it abundantly clear that private data on individuals must pertain to individuals. But, as we all know, that was a dissent. It wasn't the majority opinion, and the majority opinion controls. And it's not uncommon to have a legislative fix to Supreme Court decisions, which is what this is. My bill fixes that problem, and I believe it is a genuine problem. I don't think there's much doubt about that. So I respectfully ask the committee to vote in favor of transparency and to vote yes on Senate File 730.
All right, I'm going to reiterate my admonition here. I do not wish to have parties characterizing other parties' positions or engagement in discussion or negotiations or anything like that. That's beyond the merits of the bill itself. I want our discussion to focus on the merits of the proposal only. Ms. Primo, do you have anything you'd like to supplement with regard to the history or providence of this bill?
Mr. Chair and members, I'll provide a brief overview of the court decision that led to Senate File 730 in case it is helpful to the committee members. Energy Policy Advocates versus Ellison was decided by the Minnesota Supreme Court in September 2022. In addition to the data practices issues, the court did also address issues related to attorney-client privilege and the work product doctrine. I'm setting those issues aside for the purposes of this overview. The case came before the court because in December 2018, Energy Policy Advocates requested data related to the Attorney General's retention of Special Assistant Attorneys General to advance certain multi-state litigation. Specifically, Energy Policy Advocates requested correspondence to and from some particular person, which included 11 search terms that ranged from referencing an external law firm, other state AGs, private advocacy organizations, certain websites, certain software applications. The court stated that the AG initially relied on 13.393 as the basis for withholding the data, but later claimed used 13.65 subdivision 1, paragraphs B and D as the basis for withholding the data. That is the statute that is being amended in 730, in Senate File 730. The court stated that the legislature intended to classify all the data listed in paragraphs A through E of subdivision 1 as private data on individuals, regardless of whether the data is about individuals or non-individuals. Energy Policy Advocates argued that the legislature intended to classify the data as private data on individuals only if the data was actually about an individual. But the court rejected that interpretation and stated that the legislature did not include that limitation in section 13.65. And the court compared 13.65 to several other statutes in Chapter 13 and stated that those other statutes included the term on individuals as proposed in Senate File 730, and the court declined to add additional words to section 13.65. The court concluded that the legislature intended to omit those words on individuals, which is at line 1.7 of Senate File 730, and therefore intended that the private data classification would apply to all types of data.
All right, we have a number of individuals have signed up to testify on this. We're going to start with Matt Ealing from Minnesotans for Open Government, and then we'll go to Attorney General Ellison and or his staff as he wishes. Mr. Ealing.
Thank you, Mr. Chairman, Senator Kreun, and members of the committee. Matt Ealing, Minnesotans for Open Government, testifying in support of Senate File 730. Last year, this committee heard technical and historical testimony from Don Gemberling related to this bill, but I want to present some brief updates today. The passage of this bill has been one of our organization's top priorities since 2022, when the Minnesota Supreme Court issued its decision in the Energy Policy Advocates, or EPA, case. By a one-vote majority, the court overturned 40 years of interpretive history and allowed the Office of the Attorney General, the OAG, to withhold a much broader swath of its data from public disclosure. Data that the OAG is now able to withhold runs the gamut from draft policy information to inactive investigative data, data which can be attained from every other public law office in Minnesota and from every other law enforcement entity in the state of Minnesota. While Section 13.65, the section of the Data Practices Act that governs the OAG, has had certain differences from other government entities for over 4 decades, in the most important ways, the OAG operated in the same manner as the Hennepin County Attorney's Office or the Steele County Attorney's Office or any other public law office when it came to data practices matters. Now, however, the OAG has been afforded this broader data classification protection through a court decision that we believe was wrongly decided. I would note that in Minnesota, every previous Attorney General since 1979 has had to operate under the prior understanding of Section 13.65. All of them were able to operate and execute the functions of that office from criminal prosecutions to multi-party and multi-state litigation under the previous understanding of that statutory scheme. All that Senate File 730 does is return Section 13.65 to that prior understanding. The OAG's functions will not be impeded nor modified. Like other public law offices, the OAG is able to avail itself of existing, not public data classifications that protect active civil and criminal investigative data, as well as attorney-client and attorney work product material, classifications that the OAG used for decades before the outcome of the EPA case. Multi-party civil litigation will continue after this bill is passed, just as it did during the Hatch, Swanson, and Humphrey years, when the OAG litigated some of the biggest consumer protection cases in Minnesota history. Today, the OAG even now has access to the common interest doctrine per the EPA case. That doctrine allows parties with common legal interests to share attorney-client material. I would note that this is a portion of the EPA case that our organization did not object to when we filed our amicus brief at the Minnesota Supreme Court, and it would not be modified by Senate File 730. What Senate File 730 will do, though, is return the public's ability to find out what the OAG is doing at the same level of detail as it can with other public entities. In recent years, we've heard growing concerns about the OAG's new data classification regime from parties ranging from the state's largest media institutions to former data compliance official Rick Hodson. And what's clear to us is that the current situation must change. It's untenable for the state's most powerful public law office, as well as the state's chief law enforcement officer, to operate with more limited transparency than every other county attorney's office or police department in Minnesota. And SF 730 is the answer to fixing that issue. And we thank Senator Kreun for bringing it forward. And we thank you, Mr. Chairman, for holding a hearing on this so that the issue can be further discussed.
Thank you, Mr. Ealing. Before you go, Senator Oumou Verbeten has a question for you. Mr. Ealing. Senator Oumou Verbeten.
Thank you, Mr. Chair. Thank you. You had just mentioned that your understanding is the interpretation is new to this administration, but my understanding in the EPA versus Ellison case was that even though it was litigated with this administration, the challenges were made back in 2018 under Attorney General Swanson.
Mr. Ealing.
Senator, thank you, Mr. Chair, Senator Oumou Verbeten. Whichever Attorney General decided to start going down this path, to us is immaterial. You know, we're not in this to penalize or object to any particular office holder. We're saying that the understanding has changed. It changed during that litigation. And if you look back at the history of the advisory opinion process, advisory opinion 94047 issued in 1994, quite a long time ago, really clarifies the position that the Data Practices Office took on this issue for many, many years. And that was the common understanding, that data on individuals, classified data on individuals, even as it was referred to in 1365. It did not classify data on corporations or non-individual entities.
Senator Oumou Verbeten.
Thank you, Mr. Chair. And I understand your position. I just wanted to, I guess, raise that point that was being made in a letter that we did receive from the Attorney General's office, that though they were litigating in that case, it seems there were previous Attorney Generals that had the same understanding that this administration does.
Is there a question or statement? I just wanted to. All right. Mr. Ealing, you wanted to respond?
Certainly. Thank you, Mr. Chairman. Senator Oumou Verbeten, just one additional point that'll be helpful. Mr. Gemmerling, who testified in detail on this last year, he sort of reiterated to me the history of what happened after this advisory opinion was issued in 1994. So he said that the Attorney General's office at that point did not like the opinion. They disagreed with it, even though it had been the common understanding. They tried to go to the legislature to get it changed. The legislature did not change it. So they had the opportunity to bring this broader understanding. And the typical data practices nomenclature that would classify data on individuals and non-individual entities would be private data on individuals or non-public data. You see that throughout many, many provisions of the Data Practices Act. So if the data, if the Attorney General's office wished to have that effect, and that's what they tried to do in 1994, was add that additional language, and they did not. The legislature decided against it. I would also note that in our amicus brief of the Minnesota Supreme Court, we introduced the memo that Mr. Gemberling had wrote about the inception of the current language in 13.65, which expressly applied to individuals in the 1977 memo that he wrote, and then that language was then adopted into the Data Practices Act without any change in 1979 when that was enacted.
Thank you, Mr. Ealing.
Thank you, Mr. Chairman.
Mr. Attorney General Ellison, come on forward, and you can bring with you any testifiers you would like. Welcome to the committee. And members, there, you do have in your packet a letter dated today, April 24th, 2026, from Attorney General Ellison to the committee. Go ahead.
Thank you, Mr. Chairman, and thank you, Ranking Member Limber, and also all members. I want to be crystal clear. Passing this bill will impose tremendous and unprecedented burdens on the Minnesota Attorney General's office and its ability to protect people of this state. It's as simple as that. The consequences of what's being contemplated here are serious, and this is about the ability of this constitutional office to perform its duty as mandated by Minnesota consumer protection laws, and that includes antitrust. That includes more than that. And it doesn't matter who sits behind the desk at the AG's office. It will apply to all AGs, no matter who is the AG at the time. What may seem like a simple change would have far-reaching consequences for consumer protection in Minnesota. Our inability to keep private data private would chill Minnesotans' willingness to come forward with complaints of wrongdoing. Imagine a mom and pop on their dairy farm, their family dairy farm, that's organized as an LLC. Already, they have a lot to consider when they want to file a complaint against a conglomerate that's breaking the law by colluding to set milk prices. But what if the conglomerate can see those complaints that this law would make public? That mom and pop would never file that complaint, and that corporation would continue to keep on breaking the law in the shadows. Or consider a repair shop on Main Street. They want to complain about their internet provider not delivering the speeds they promised in a contract. If that repair shop owner has a reasonable fear that the internet company will retaliate by cutting their speeds or cutting their service altogether, they may never come forward, and customers in that community would suffer for it. Mr. Chairman, I talk to business people all the time, small business people, LLCs all the time, who are a corporation, but they're really a person or one or two, three people who would be very adversely affected. In fact, I can't give you the details, but as I was walking in the hall, a very situation just like that, small business people dealing with a larger conglomerate, of wanting to complain but cannot. This bill would mean that if they complained, it would be at their peril. So this bill would also cripple and undermine our ability to participate in important multi-state litigation, as other states would be reluctant to join our cases or invite us to join theirs. Why would they, when the data from their residents shared with us as part of the case could no longer be kept private? Minnesota was part of a major bipartisan multi-state lawsuit against Ticketmaster and Live Nation just last week. And we proved to a jury that they violated antitrust laws. We proved Ticketmaster and Live Nation violated Minnesota's antitrust laws by eliminating competition and driving up ticket prices. We took that case before a jury and we won. But if this bill had been law, that case could have gone on without us on board, or at least reduced us to a dramatically lesser role. And the people of the state of Minnesota would never see the benefits, or may not see the positive benefits. And what about Minnesotans' successful effort to hold opioid manufacturers accountable for the death and damage they inflicted on our state? If this bill had been law, Minnesota may have missed out on historic settlements that brought in over $560 million to our state, which goes back to state coffers and local governments, with every last dollar of it going directly to treatment, remediation, or prevention. Mr. Chairman, let me just say that I'm aware that some special interests and their allies seek to weaken this office as seeing that as a positive thing. Indeed, this attack on the ability of the Attorney General's office to stand up for Minnesotan consumers comes directly from big oil, the same deep-pocketed special interest that is currently profiteering off war in Iran at the expense of Minnesota households. Special interests and monopolies want Minnesota to pay more. They want to keep Minnesota's exceptional nation-leading consumer protection team off the big national lawsuit because we know we win for Minnesotans. They want mom and pop to keep quiet and put up with the mistreatment they may suffer from their corporate overlord because it makes them money. But these factions are only thinking about their profits and multi-million-dollar executive bonuses and stock options. Let me just conclude, Mr. Chairman, by saying that I am still unaware of what data the proponents say they're entitled to that we have not given them. It's a theoretical conversation, not directly tied to any data that anyone has asked us for, we have complied and been willing to talk at all points. And so I'll just conclude by saying to you, Mr. Chairman, my promise and pledge to you, sir, is to talk with all parties who want to do this and to try to come up with some sort of language. But at this point, I'd ask this committee to just turn this bill down and we come back and have a reasonable, sensible conversation on how we all move forward. And I ask for a no vote. And with that, we have several experts on data practices at our office. One of them is Mr. Oliver Larson, and with your permission, Mr. Chairman, I'd like to ask him to make remarks.
Thank you, Attorney General Ellison. Mr. Larson.
Chairman Latz, I'm going to try and stay brief and just try to, I don't want to say correct the record, right, because that seems pejorative, to your point of trying to keep this at a high level. And I will say that we met with Senator Kreun, and I found him to be a person of good faith. I think there's some disagreements, and I want to highlight those, but it's in no way designed to impugn Mr. Kreun or anyone else, or Senator Kreun. So one issue I want to clarify is this argument that's being made that there was a shift in the office's position on 1365 recently. We would contest that. I'll say that as politely as I can. And I can point you, we've got a letter from 1977 that the prior speaker spoke of. There was essentially like proto-legislative activity that took place before the Data Practice Act was passed in 1977. And much of the language of that kind of proto-activity then became 1365. And I have a letter here that I could share with the committee from 1977 in which Byron Starnes, who was working in our office at the time, sent a letter to the Department of Administration setting forth what the Attorney General's position was on this kind of data. And it's the exact same position we take today, which is if there's data that's covered by 1365 that's about an individual, they should have access to it. But if it's not data about an individual, then it should remain confidential, or in this case, private data on an individual. That was the purpose of this. And so, you know, I can, if we had a lot of time, I could take you all the way back to 1977 and show you this is not some new novel interpretation by our office. It's a long-standing interpretation. And again, returning this issue of, we have queried advocates about what is the specific data that you're interested in so we can have that conversation. And really the only data that's ever been identified is this data about the office's retention of special fellows who work within my division to do some of the work in environmental natural resources work. And here's what I'll say about that. We have produced that data. We have never classified that data as being protected by 1365. The reason it wasn't produced in response to the data requests in 2018 is it didn't exist. We do have some fellows working for us. Those fellows were not hired to work in our office until the middle of 2019. And after they were hired, we got essentially the same data requests we had gotten in December of 2018, and we produced the data. So if anybody wants to know what the arrangements are between our office and the State Impact Center or New York University or anyone under which we have fellows working for us, that's all public data. We have never said that it wasn't, and we will produce the data, and we have. So if that's the concern, you know, I don't think we need an amendment to 1365 to deal with it. And as we outlined in the letter, there are all kinds of other data that's going to become public if this change is made. And I think there needs to be a conversation about whether that makes any sense. Does it make sense to have consumer complaint data actually becoming public in an effort to turn over data, you know, in an effort to search for data about retention of fellows that's already public? So maybe I'll stop there. I'm happy to answer questions. I probably should have introduced myself to start. My name is Oliver Larson. I'm an attorney. I work at the office. I've been there since 2012, and I'm currently the manager of the Environmental Natural Resources Division. I'm also the attorney who handled the EPA versus Ellison matter.
Mr. Chairman, we also have the chair, the manager of our Consumer Protection Division here. We also have the deputy of Consumer Protection. The manager is Mr. Jason Plagencool, and he could help the committee understand how this particular bill would impact our ability to conduct consumer protection. And with the chairman's permission, I would ask that he be allowed to make brief comment.
Sure, that would be fine. Mr. Plagencool, come on forward. Go ahead and introduce yourself.
Good morning. Thank you, Chair Latz. My name is Jason Plegancool. I'm the manager of the Consumer Protection Division of the office. And I really want to emphasize two main points about how this bill would severely make it harder for our office to both investigate fraudulent, deceptive, and anti-competitive practices and bring suits when we find unlawful conduct. The first is what this bill would do to consumer complaint data. Consumer complaints are really the lifeblood of the work that we do. We rely on hearing from consumers in real time, both individuals and small businesses, about what's happening out in the marketplace, how they're being impacted, what issues they're facing. And right now, those consumers, those small businesses, they can come forward to us and tell us about those concerns with the certainty that they know what they share with us is not public. And that goes for both small businesses and individuals. If this bill became law, that would no longer be the case. And that would certainly chill the submission of complaints we get from small businesses about deceptive, unfair, and anti-competitive practices they're facing. And I think Attorney General mentioned this, but the Ticketmaster Live Nation case is a really good example of that. That case, the foundation of that case began with consumer complaints, both from individuals and from small businesses across the country and in Minnesota. Smaller entertainment venues that were feeling the anti-competitive practices of Ticketmaster and Live Nation. If this bill had been law at that time, there would have been nothing preventing Ticketmaster from submitting a data request to our office and learning about each and every small business that had complained to our office about its practices. And it would then be able to use its monopoly power to retaliate against those businesses. This type of threat, even knowing that that could happen, would certainly chill submission of complaints from small businesses and their willingness to talk with us after they submit a complaint. And so there's some real concerns about what this would do to our ability to both hear from people who are experiencing unlawful activity and us being able to follow up and talk with them about it. The second point I'd like to make is on the inactive investigative data and what the bill would do to that. This bill would also chill cooperation from entities under investigation. Right now, when we begin an investigation, the conversation we always have with the target of that investigation is how is the office going to treat our data we produce that you're asking for? And right now, we're able to tell those targets that data, both while we're investigating and after we're investigating, is non-public. If we get a data request, we would not provide that information. If this bill became law, we wouldn't be able to tell those targets that any longer. Instead, we'd have to say, if we got a data request after the investigation ends, we'd have to turn that information over to whoever's requesting it, whether it's a competitor, a private attorney, anyone else. That is certainly going to make it more difficult for us to gain cooperation in our investigations when we're investigating a target. It's something we're very concerned about happening. It would also create just an unfair double standard for people we're investigating. If we're investigating an individual, that inactive investigative data would remain non-public. But if we're investigating a business, it would become public. And so there's just some real serious concerns with the impact this would have on our work in consumer protection. And I guess just one other point to make on the investigative front is what this would do to our multi-state investigations. It's a big component of our work. And right now, we're able to fully participate in multi-state investigations with both state and federal partners. Most states, almost all states, have similar data practices provisions that provide for information to be non-public during and after investigations. This would really make us an outlier, and we would likely be held at arm's length if we were allowed to participate in these investigations. We wouldn't have the same access to the investigative data gathered by other states, and there would be real concern from those states about what would happen to that data after the investigation ends, if it's provided to us. And that would really hamper our ability, especially to lead these investigations, which at any given time, we're probably leading half a dozen large multi-state investigations on behalf of consumers in Minnesota and across the nation.
Mr. Chairman, if I could just have one last point.
Mr. Attorney General.
You said to me, because you and I have been friends for years, Keith, I want you to talk to folks and see if there's a way to move forward. I'm still committed to that. The procedural history of this particular moment is that this bill goes to HHS, this amendment is tacked on, and now here we are. And so we really haven't had that opportunity. I'd be more than happy to talk to whoever. I can't compromise the ability of the AG's office to do consumer protection. But if there is some way to meet the needs of everyone, I am open to that dialogue. But I absolutely urge a no vote today. So that's all I wanted to say.
Thank you. Mr. Attorney General, you had some other staff that were listed here. Is there anyone else from your staff that you would like to present anything? We're going to give Mr. Elling an opportunity to respond as well. So.
Certainly. I think that we're trying to make sure that the committee, we use the committee's time in the most efficient way we can. So our team has consolidated into 2 testifiers. But if I may, is there anything that needs clarification? At this point, there's nothing that needs further clarification. I would ask the chair for an opportunity to respond to whatever the proponent says, but for now, we can rest.
So I do have a question for Mr. Pleckenkool. Sir, do you see a need, given the apparent ambiguity that was in the statute, or maybe the lack of ambiguity that led the Supreme Court to decide on the language on its face what they did, for any clarifying language in the statute to address the concerns you've raised?
Chair Latz, not as it exists today with the EPA decision. I think it's clear. There would be a lot of concern if the bill was passed, though.
No, I'm not asking that question. I'm asking, let's step back from the Supreme Court's decision. The statute on its face, in order to meet the concerns of the Attorney General's office, but also make sure that data that public policy might think ought to be public, would the statute itself need any clarification so there isn't any ambiguity? So no one has to go back and read the EPA decision to figure out what the statute really means. I'm not asking for language today.
Okay.
Right now, I'm just asking, is there room here that we might need to clarify the statute? Mr. Attorney General.
And what I'd like to say, Mr. Chairman, is that it's possible. But I would far prefer to do it without a vote pending any minute that could devastate my office. So I do think it is possible. That's why I'm open to the dialogue. I mean, you know that I'm a straight shooter. If I said there's no room, either we win or they do, but I'm not saying that. I'm saying that we'll be willing to have a conversation, but with the hammer hanging over our head as it is at this very moment, where I'm staying up all night hoping that we can continue to serve the 5.6 million Minnesotans who depend upon us to do consumer protection. I just don't think this is the right moment to rewrite Section 13. So I'm pledging to you that we'll have that conversation. There might be space for clarification. At this moment, I'm reluctant to think of it, because anything I would say, I might have staff say, well, wait a minute, Keith, what you don't know is this, this, and this, and this. And so I just think writing legislation on the fly isn't a great thing. And as you know, you and I served in the legislature together, so I do know a little bit about it, and not as much as the members of this committee, but I've had some experience with it. So I just ask for a no vote on this, but a promise to have some conversations to see if we can find that point of agreement that I pledged to you that I would seek.
Thank you, Attorney General Ellison. All right, we're going to ask you and your staff then to open up the testifier seats, and we'll ask Mr. Ailing to come back, who's indicated. All right, Mr. Neumeister, if he also wishes to testify, to come back to the testifier table and to offer your perspective, and then we'll open it up for conversation here among members of the committee. Mr. Ailing.
Thank you, Mr. Chairman, members of the committee. I just want to address 2 points. The first would be the assertion that the withholding of data is theoretical after the EPA case. I would refer the committee to the testimony that I submitted the last time this bill was heard back last year. On page 14, I've reproduced relevant portions of a letter that I exchanged with Mr. Michael McSherry of the Attorney General's office. As members may know, outside of my volunteer role at Minnesotans for Open Government, I also do a wide variety of volunteer activities requesting data from state and federal agencies. And a couple of years ago, I made a request as the Feeding Our Future issue started to break. I made a request to the Attorney General's office for a couple sets of data. One was data related to how the office certified the reauthorization of the nonprofit status of Feeding Our Future, and then was also curious to get civil investigative data when that case, any case that they had pending against that organization was inactive. And Mr. McSherry, in his response to me, basically provided data that showed the final production of what the Attorney General did when it recertified status of Feeding Our Future. But it said that anything prior to that final documentation was now non-public under the EPA case, and also said that even though I had said I was willing to wait until the civil investigative phase was complete when such data would be active and non-public under 1339, the civil investigative data provision, Mr. McSherry said, also you should understand that per the EPA case, inactive civil investigative data are not public per that case and that decision. So these are not theoretical concerns. And again, I would note that inactive investigative data at a county attorney's office, at a police department, I have requested a lot of that data over the course of time. So in other entities, that information is public. And the second point I would make is in regard to new language. You know, we are certainly willing to talk to folks if there are specific concerns. There are consumer protection related provisions within 1365 that, as the testifiers have talked to, seem to cover individuals or non-individuals. So we could certainly have those kinds of discussions, but I would note that there's very, very important data that was previously available from this office, inactive investigative data, policy information. And just as a final point on prior data requests I made a request in 2017 to Attorney General Swanson because someone had contacted me concerned about some of the immigration actions that the Trump administration, under its first administration, was taking. And the AGO had filed an amicus brief in one of those pending cases and wanted to know what happened. And I got about 200 pages of information that included correspondence from attorneys with attorneys at the University of Minnesota who were participating in that case. There was a lot of information in there that showed the process of working through the issues as they related to those actions. So again, I would say this is not theoretical, the concerns that have been raised. Thank you.
Thank you, Mr. Ailing. Mr. Neumeister.
Mr. Chairman, members of the committee, I just want to say in a general sense, I've been around a very long time on what is public, what is not. And I know what transparency and accountability is. And it's in that vein that I make my comments. Minnesota has long prided itself on strong open government laws. Been around a long time to where I know where the Data Practices Act was designed to make sure that the public can see how their government operates, especially in powerful offices like the Attorney General, which represents all Minnesotans in court and shapes major policy. The EPA case weakened that transparency. The ruling expanded the Attorney General's ability to classify broad categories of data as non-public, because they said an individual, which has been defined as a real person, is now a corporation, as we've already discussed about that. So this creates unnecessary barriers to understanding how the Attorney General's office has exercised its authority on critical issues, and there's a number of them, and some of them were talked about today, and other areas that affect individuals, businesses, and Minnesota families. This bill, and even in the amendment that was done in the previous bill that's been referred to, offers a targeted common sense fix. It clarifies data classification in the AG's office from what I believe is to restore the original intent of what that part of the statute is. The bill carefully protects legitimate investigative work, attorney-client privilege, and active litigation, while it's reestablishing the presumption of openness for administrative and policy records. And importantly, which was just discussed, about closed and inactive files. That's where you get a lot. Did the AG do their job? Did they not do their job? It's just like when a city attorneys do civil suits or whatever, or county attorney, whatever. You see, were they able to do their job? Did they do right? Was there anything questionable about that? Transparency in the Attorney General's office is essential, because this is not just another agency. It wields significant power on behalf of every Minnesotan. When the public cannot access records about how decisions were made, even years after cases are closed, trust in government erodes. Sunlight remains the best disinfectant. You know, I just say a core Minnesota value: no office is above accountability. Now, I am just here as a citizen, a public person. I'm not a special interest. No office is above accountability. And I can only say with my heart and my involvement is that this office has come to that point, unless there is some recognition that we have to do something to make the office more accountable and transparent and more answerable to the public they serve. So, Mr. Chairman, those are my strong comments. This is hard to understand, the law. I'm aware of that. But we've been discussing this for a year and a half since it was when I first appeared on this committee last April or March or whatever it was. But, Mr. Chairman, thank you for your time. And I encourage you to pass this legislation either in this form or in the amended bill.
Mr. Neumeister, one of the concerns that's been raised is the disclosure of the identity of complainants after an investigation is no longer active if the complainant is not an individual but rather is a small business, whether it's a consumer complaint or the targets of investigation.
Now,
what are your thoughts on that?
Mr. Chairman, in regards to, if you look at 1365C, which is investigative data, it basically says on individuals.
Can you please get closer to the mic?
Oh, I'm sorry. If you take a look at 1365, 1C, if I don't have the language in front of me, it says basically investigative data, or I'm sorry, C, consumer complaint data. So when I complain, all that is data. It's private. The data on individuals. Now, a small business or things like that, I mean, that's a legit question. I have to ask that question. I don't know. If it becomes inactive, is the business who's investigated or whatever, public. But it's very clear, as I look at the statute, is that consumer complaint data basically is private data on individuals. So the person would not be necessarily identified.
No, but Mr. Neumeister, the concern is that if the complaint were made by a small business and the bill that proposes to protect only individuals, and then the small business identity would need to be disclosed under the proposal. Mr. Neumeister.
For years, more than likely, if it was a small business and an inactive file or any business, a business complained, maybe under 1339, it would be, the identity of that would be public. But for individuals, just plain as it was said, I mean, individuals and small business was used back and forth here in many different ways. But it's very clear, if I, Rich Neumeister, complained about an entity that's doing bad things to me, that name would be private, as I read the statute. But for 40 years, businesses, corporations that may have complained, whatever. And that's one of the things that's the dynamics, because, as you know, individual corporations and small businesses are not treated as a human being. They're treated under non-public. Now, if one of the things that you want to change, if that's the main thing, you can easily say the identity of the non-public, whatever you would classify that the name of the business shall be private. But everything else then would become public. It's the way the court made this decision and how we're trying to deal with it is it made a broad swath. And now anything that the AG is deciding a lot is, well, that's not on an individual, but the EPA decision allowed us to make it not public, so that's what they're doing.
Mr. Neumeister, my concern, I'm a professional association. In fact, my professional association was the target of a fraudulent transaction in the last 2 months. So if it were disclosed that Ronald S. Latz, PA, which is the name of my private corporation, had made a complaint and the investigation gets closed and it's inactive data, and then that has to be disclosed in response to a data request, it'd be pretty clear which individual who made the complaint, and I could be targeted for retaliation by whoever I made the complaint against, theoretically, under the language that's proposed in Senate File 730. Would that not be the case?
Mr. Chairman, first of all, the language that's being proposed is basically going back to what we've had for 40 years. Secondly, a good point. I'm just telling you what I'm saying. And then if they want to make that a private entity private, then let's do that. But as you indicated last year in public discussion, there is a sense that something has to be done. And again, here's an opportunity to do something. So.
Yeah. Thank you, Mr. Neumeister. Okay, we're going to open this up now. You can go ahead and return. And we'll open this up now for discussion from members of the committee, or questions, if anyone has one. I have Senator Seeberger first, then Senator Oumou Verbeten. Senator Seeberger.
Thank you, Mr. Chair. I'm going to preface my comments and my question by acknowledging I am not a data privacy expert. And
you are
so,
now.
Well, these are genuine questions that I have. I have read the Energy Policy Advocate's decision and the dissent, and I have section 13.65 in front of me right now. In reading, and I've struggled with data privacy issues over the course of my 30-year career as an attorney. And in reading the definitions in 1302, subdivision 3, I note that individual means an individual. And it is not defined expansively to include LLCs, PAs, nonprofits, whatever might be, corporations, small businesses, and perhaps, and I go back to the question you raised earlier, Mr. Chair, that perhaps some revision is needed in the statute to address some of the concerns that are being raised. I don't think that's work for today, though. in listening to the concerns raised by the Attorney General's office that this would impact multi-district litigation, that it would allow data on corporations, small businesses to become public. My genuine question is this: does not subdivision 2 of 13.65 address that and create that as confidential data?
Who would you like to address your question?
Perhaps the Attorney General or his staff could answer that. Or Senator Kreun, or anybody who might be a bit bigger data expert than me, because I don't know.
Who wants to tackle it first?
I'm looking at the confidential, subdivision 2 confidential data of 13.65.
Mr. Larson.
If you give me 1 second, or sorry, Chair and Senator, what I'm trying to pull up is 1302, because you were citing to the definition as well. There are some, the Data Practice Act is just frankly very complicated. And so if you get into 13.02 in the definitions, and there was extensive briefing on this issue in front of the Supreme Court. If you actually read the definitions of data on individuals, it's not actually limited to data on individuals. Those words don't actually appear in the definition, and that's intentional. Because as you go through different parts of the Data Practices Act, there are places where data that's not about individual gets shoved into that definition. So it can be hard just kind of as a lay person to pick up whether it's 1365 or 1302 and read these definitions and have an intuitive understanding of what they're really trying to accomplish.
Right, and I'm going to agree with you there. Thank you, Mr. Chair, that data on individuals, which is not on individuals, is often shoved into the data on individuals category, and that has been the source of my confusion for many, many years as I've tried to unravel data privacy questions. And that appears to be what happened in the Energy Policy Advocates case. I guess my bigger question, however, is, and thank you for that, wouldn't the Attorney General's concerns be addressed by subdivision 2 of 13.65, which states the following data created, collected, and maintained by the Office of the Attorney General are confidential? And that data is data acquired through communications made in official confidence to members of the Attorney General's staff, where the public interest would suffer by disclosure of the data. Doesn't that provide a big enough blanket protection to protect the data that the concern was raised about? Or does this, am I not understanding how this statute works?
Mr. Larson.
Yeah, Chair Latz, Senator Seberg, can you, which specific section are you looking at right now?
I'm looking at, Mr. Chair,
Senator Seberg.
Minnesota statute 13.65, subdivision 2. So a little further down than the part that this particular bill is seeking to amend. Subdivision 2 entitled confidential data. Would that not protect the data that the Attorney General's office has raised concerns about?
Mr. Larson.
Chair Latz, Senator Seberg, but no. There would be other issues. I agree with you that this data, we could make an argument under this provision of the statute to protect, for example, LLC data, if that was our concern. One of the issues is they would be then subject to challenge, right? We would have constant litigation from parties that want this data about whether we had made a correct decision or not, about whether this data should be protected. And so, you know, I would counsel against trying to rely on provisions that invite litigation over provisions that provide clarity. That's one issue. The other issue is that would really only fix maybe this kind of individual versus LLC issue. We would still have lots of information that is not consumer complaint data that would be of concern, and that would not be something that we could put into sub 2 because it wasn't communications from a member of the public to one of our staff.
Thank you, Mr. Chair.
Senator Oumou Verbeten.
Thank you, Mr. Chair. I share the concerns that you've raised and Senator Seberger, but I just want to get clarification from Senator Kreun. If it's your intention with this bill that if there is consumer complaint data from a small business, is it your intention for that to be public?
Senator Kreun.
Thank you, Mr. Chair. Senator Oumou Verbeten. My intention is to bring this back to the way it was pre-2022. There is legitimate public policy considerations to treat corporations differently from human beings and individuals in this part of the statute. And that's how we've been operating for over 40 years. There may be other areas within the statute to protect that information depending on what the circumstances are. But I would say that the presumption under our Data Practices Act is that that data should be public, unless the legislature determines that it should not be public. And so with that in mind, my position on this is that we should return to the way this has been done for over 40 years. And if our other exceptions and other parts of the statutes are insufficient to address certain situations, then we could take a look at amending the statute at that point. But what we shouldn't do is just wait and not act on this, which has sweeping implications, because there might be some micro instances that the statutes might be needing cleaning up, when the presumption is for data to be public.
Senator Oumou Verbeten.
Thank you, Mr. Chair. Thank you, Senator Kreun. I guess I would argue that this could also have sweeping implications if all of that data, consumer complaint data from small businesses becomes public, and have concerns about them facing retaliation or just it jeopardizing the consumer protection work. And I hear what you're saying about there is a difference between how we would treat individuals and corporations. But again, my specific concern would be consumer complaints that come from a business. And so I'm trying to understand your intention here, right? If you think, if it's from a business, it should just be public. Or if you think there are situations where, a consumer complaint from a business should remain private data.
Mr. Chair.
Senator Kreun.
Thank you, Mr. Chair. And I would just say that there's many data from businesses that aren't going to just become public. There's lots of other protections within the Data Practices Act that would make that information not public, or at least for a while or until a later date, pending investigations, that sort of thing. And to counter the response that this bill is some seismic change, I would submit that it isn't, because again, we're just going back to 2022. That's all this bill does. And so the sweeping change came with the Minnesota Supreme Court decision. This just brings it back to the way that the office had been operating for over 40 years. And I understand that maybe not all attorneys general liked the interpretation and how that was, but the fact remains they complied with it and operated that way for over 40 years. So this is not a seismic change in any way, shape, or form.
Senator Oumou Verbeten.
I guess it would be helpful to hear maybe from the Attorney General's office if prior to this case there were instances where there was a complaint from a small business that was made public.
Attorney General Olson. Mr. Larson.
Mr. Chairman.
Attorney General Olson.
Yeah, and Senator Verbeten, we went to the Supreme Court because of our interpretation of the Data Practices Act. That's why we ended up there in the first place. So I don't agree that the Supreme Court decision was the sea change. The Supreme Court was the resolution of a difference of opinion. Now, I would tell you that we routinely deal with small business people who have complaints against their franchisor, against a whole range of people who small business people may have a conflict with. And we would like to treat it like we would consumer data from people, because it's that critical. So I think I would disagree that the sea change was created by the court. The court resolved a conflict and difference of opinion that had been going on for a while. But may I also just add, we're not against trying to find the right space. I just don't think it's the right thing to do right here, right now. There might be some place to work this out, but there's just too many ways for this thing to go sideways and have unintended consequences to just pass this bill this way now. And the last point I'll make is, look, not every single investigation that we start results in either a settlement or a lawsuit. Some of them, things look problematic. We get into it and we find out that they're not. I can think of specific instances in which that has happened. And they're like, no, we're complying, he, C. And we're like, yeah, they're right. In that situation, does the legislature want those folks to have all of their information subject to everything? I don't know. It would make us, it would raise the threshold for us to start an investigation, and it would create reluctance on their behalf to share anything with us. I just think that there's a lot of complicated issues that we should take the time to seriously consider before we move today. So I urge a no vote.
Senator Oumou Verbeten.
Thank you, Mr. Chair. Appreciate the discussion. I don't have any more questions, but I just wanted to point out that in the existing law, in Section 1, Subdivision 1, Paragraph E, there's also this mention of the name and address of the mortgage company. I think the Attorney General mentioned this in his letter as well, but that seems like an example of something that's not data on an individual, but is clearly related to an individual, that's kind of looped into this definition of an individual. Mr. Larson kind of spoke to that, as you see that throughout Chapter 13. So I would agree that I think there's more work to be done. I just would be concerned that the approach this bill is taking would force the Attorney General's office to make public consumer complaint data that comes from small businesses. So I can't support that. But that's the option before us today. So that's where I'm at. Thank you.
Senator Holmstrom.
Thank you, Mr. Chair. I guess I have a question for the Attorney General. Your office holds an incredible amount of power in its decision to either move forward with charges or to not. And there's very little oversight on how that decision is made. My concern is that when we limit public disclosure and take away the public's access to see how those decisions are made, we could lead to a world where corruption could occur and we would have no idea. Is that well-founded? I mean, could you see a world where a future Attorney General might fail to charge something and we not know the reason was corruption?
Attorney General Ellison.
Let me tell you, I think that it is important for, excuse me, Mr. Chairman, Senator, it is important for you all to be able to call any Attorney General or any officer in here to come in and answer questions. I think it is important to understand that when that we should have a Data Practices Act, which provides for the disclosure of information. I also think that we don't have to undermine the investigative function to do that. So what I'm saying, you're asking me a question which in general and in theory, I agree with. We should be able to know what's going on. But when it comes to age-old privileges and valid public policy reasons, as we've articulated here, what it requires is that we just take a much more delicate approach than it feels like we're taking to me right here, right now. So I would say to you, finally, that it's not for the sake of the Attorney General's office that the data practices exceptions exist. It's for the consumers so that they feel comfortable coming forward to say, this happened to me. And I'll tell you this, multiple times this week, I'm talking about today is Friday, since Monday, I've been in agricultural communities and I've been in urban environments and suburban environments where small business people have come to me and said, this big company that I'm work with is doing me wrong, and I need you guys to look into it. I'm telling you, I can't name the company and I can't name the people, but when I walked to the bathroom, I was stopped by somebody who said, hey, my small business group is gathering information for you vis-a-vis this big company. And so I want to be able to do that. I think you want me to be able to do that. So let's just sit down and figure it out and not pass a bill that doesn't work, but maybe pass one that meets your needs and the interest that we're speaking up for right now.
Senator Holmstrom.
Thank you, Mr. Chair. I'll give a more specific example from my district. There's a large home manufacturer who had defects in their windows, and an entire neighborhood had leaky windows, and the home manufacturer came back and said, well, you have to sign this NDA and agree to all these terms, and we can sue you if you choose to tell your neighbors about this. And the whole neighborhood decided that they weren't going to sign it. And over time, bully tactics were used, and now there's only a few left. And these individuals are in a really bad state, and they've reached out to your office, and your office, they haven't heard anything back from. And they've asked me, well, can we find out why he's not doing this work, why the AG isn't doing this? We want to do Data Practices Act to figure out why no investigation ensued. And right now they can't. And this seems like this would address that for them. So I guess that's really what I'm trying to do. I want consumers in our state to know what's going on, to understand and to be assured that that nobody in your office is colluding with some major conglomerate. And I think that they deserve to have that clarity. And I mean, many of them were probably your voters too, obviously. So I think that's a reasonable request that I believe this bill is trying to address.
Mr. Attorney General.
So all I can tell you is I'm not aware of that situation. There's a reason why I do like multiple community meetings a week so that I can be in touch with people. And people do sometimes come up to me and say, hey, I filed a complaint. What's going on with that? And then I go call up my consumer protection people and say, what's the status on that thing? There's a lot of, so your constituents can absolutely call me. My number is 651-296-3353. I will respond. I'll even go talk to them. But it could be that we either are trying to we could be finishing up cases that we were working on when this happened. It could be that we're in the middle of an investigation. I just don't know. I can assure you that I absolutely want to be responsive to the community members you're referring to, and will absolutely do so. You and me can go talk to them together. I'm happy to do that. But there is no nefarious reason, okay? And I will assure you of that. And if you did give me the name, don't say the name, but we'll talk one-on-one and we'll get to the bottom of it, no problem. That's what I can tell you for now. But we've done a lot of housing related stuff. We took Prettium to court. We've taken a number of housing related problems to court, but we have limited staff and maybe they just haven't got to that yet, or maybe it's in the middle of investigation. I just don't know. Let you and I find out.
I'm a little bit concerned with Senator Kreun's comment that we should just do this now and then sort out known or anticipated ancillary consequences within the Data Practices Act later. That's the way I interpreted. Let's get this passed, and there might be something else we have to fix in the Data Practices Act later. We can address that later, and maybe that's not what you intended, but I certainly wouldn't want to. If we can figure out now that there might be ripple effects in 2 or 3 other provisions in the Data Practices Act that would be impacted by passing this bill, I'd rather sit down and figure out what those are before passing the law than figure it out afterward, or especially if we're anticipating that it would happen. I'd want to address it at the time that we do it as a package rather than start out with one piece and then go back to try to fix other stuff later that we could anticipate or knew about. There are always unintended, unknown consequences, but where there are unintended but known consequences, I think we need to figure those out ahead of time.
Mr. Chair?
Senator Kreun.
I think I would characterize these as unknown consequences, potential consequences. I go back to the fact that, and the reason for why I would say that is because all this bill does is go back to 2022, where they've been operating this way for 45 years. And we didn't get a laundry list of examples during those 45 years about all of these problems with how the attorneys general were operating under this statute during that time. So what I meant by what I was saying previously is that if there are these unintended consequences, I would characterize them as potential, unknown, then somebody can bring a bill and address that. What my bill is addressing is the known consequences, what's been happening since 2022, and the implications of that.
So I think we've identified some potential complications of however the AG's office is working beforehand. And maybe there was just some stuff that wasn't being disclosed in the past that it was appropriate not to disclose, and the statute was ambiguous about the question. It could be that one of Senator Holmstrom's constituents' houses is not owned by that individual as an individual, but instead is owned by a corporation. I know people that have put their houses into corporate ownership for liability reasons or whatever reasons that they've done that, and then if that, let's say there's an investigation done and it turns out there is or there is not a violation, as Attorney General Ellison identified, and then the inactive data that got submitted as a part of the investigation, and the home manufacturer finds out who it was that made the complaint, they could go ahead and retaliate. So I do worry about the chilling effect on making complaints. If the Attorney General's office has to disclose, look, we'll investigate, we may not find anything, but once the investigation is done, the company that you complained about is going to find out that it was you or your small business corporation, whatever it is that complained. And then they might say, well, I'm not going to take that chance because they're going to come after me. I just think we need to anticipate this now. We need to think through what these issues might be and address them in a more comprehensive way than a two-word change in the statute. And I think we need to address it. Absolutely, I think we need to dive in. To me, this is more complex than we can handle today in judiciary. On a couple weeks past deadline, 3 weeks left in session, but we've got the Attorney General's commitment to sit down and work on these issues. Senator Kreun, Senator Clark, that I know has been engaged in these conversations along the way as well. So that's where I'm at. Senator Kreun.
Without crossing your admonishment from before, you know for a fact that I've been willing to work on this since early last year. I'm always willing to work with it, and I attempted to do so, and I'll just leave it at that.
I understand. And I'm going to assume everyone's prepared to move forward in good faith to address the issues that have been raised here. But I did indicate that we were going to take a vote on the bill here today, or take action on the bill. See if there's any further discussion before we entertain a motion on it. I'm not seeing any further action. Senator Kreun?
Thank you, Mr. Chair. I'll just brief closing remarks. Appreciate the committee's attention to this and for the dialogue. I responded to a couple of points. There's just a couple of more points that I would like to respond to. As the testifier said, the way that the current state of the law is now after the 22 Supreme Court decision, the Attorney General is treated in a different manner than the executive agencies and all other public entities, including the county attorneys and the police departments that we heard testimony about. They operate largely on a complaint-based system too, yet they follow their data practices are such where this information that's at dispute here would become public. We heard testimony about that. And I appreciate the Attorney General's willingness to say, I'm willing to go anywhere and answer questions about anything, and I'm available. That's great. But again, we need to trust but verify. We need to have access to the underlying documentation. It's not just about a discussion and a Q&A with the Attorney General. And I would also say the fact that, however other states are doing it in these multi-state litigation scenarios, Minnesota is known for its transparency. We have laws that are, generally speaking, more transparent than other states, and that's a public policy decision that this state has made for 50 years. So that to me, there is not a reason to not move forward with this litigation. And I would also say that with respect to multi-state litigation, previous attorneys generals have been able to successfully navigate that, quite successfully, I might add, operating under how this existed prior to the Supreme Court decision in 2022. I would submit that multi-state litigation can be done and will be done successfully if my bill passes. My bill will just bring more transparency. And I would say also that really what's really concerning about this and why I don't think it should wait is we're talking about inactive investigative data. We're talking about policy data. These are all very timely, very important things for the public to understand what the Attorney General's office is doing and the decisions that it is making with respect to a large variety of issues, but particularly fraud. We need to understand at the conclusion of these investigations why the Attorney General's office chose to do something or not do something. And the public is entitled to that information to hold their government accountable. This isn't about interest groups from my perspective. I can assure everybody this is a good government perspective. I don't quite care what the circumstances were that led to that particular lawsuit. I care about how our government is operating, and I care about transparency, and I care about giving the public the right to hold their government accountable, and that's what this bill is about. So I appreciate the committee's time, and I respectfully ask for a yes vote.
Senator Kreun, right now there's not a motion on the table. Would you like to make a motion?
So moved.
Roll call, Mr. Chair.
Okay. Would this have to go to finance? We're just trying to check on whether there's a fiscal note that would apply here. Apparently, the House file counterpart to this may have a fiscal note, so we got to figure out what the direction is for here. Mr. Larson, do you know something about that?
I'm aware that there is a fiscal note that was submitted last year, and I believe it was to the House, and our staff would.
And the language in the House file is identical, is that correct?
I believe so.
Apparently, there's a $658,000 fiscal note reflecting increased staffing needs to respond, I would assume, to data requests. Yeah, $329,000 per year. So with a fiscal note, the appropriate motion would be that Senate File Number 730 be recommended to pass and be re-referred to the Senate Committee on Finance. Is that your motion, Senator Kreun?
Yes, I'll move.
All right, and there's been a request for a roll call. The clerk will take the roll.
Chair Latz?
No.
Vice Chair Oumou Verbeten?
No.
Senator Limmer?
Yes.
Senator Clark? No. Senator Holmstrom?
Yes.
Senator Kreun,
Yes.
Senator Pappas,
No.
Senator Seeberger,
No.
Senator Westland,
No.
Senator Westrom.
Yes.
There being 4 in favor and 6 opposed, the motion does not prevail. Thank you, members, for your testimony on this. Members, the next bill up is Senate File 2689, Senator Johnson Stewart.
I'm sure, I'm always willing to move forward. I'm always willing to. Good, me too. Okay, very good. All right, thank you. Sorry, am I in your chair?
So members, the packet is being distributed. You'll see that there is a lengthy committee route that this bill has taken. We have heard Senate File 2689 before. This is relating to consumer protection, specifically Medicaid fraud. We had passed the bill out, and it went to Health and Human Services from there, and then from there it went to the Human Services Committee. It is now back to us because the Human Services Committee adopted an amendment that placed this in, that was entirely content-wise Judiciary Committee amendment, or yet they adopted it and referred it back to us. It's my request that we strip the bill of the judiciary-related amendment that was adopted by the Human Services Committee. Members, that amendment was the exact language from Senate File 730 that we just had a lengthy discussion on. And it appears to be the will of the committee that that language not move forward. So, Senator Johnson Stewart, did you wish to add anything, or just want to be able to answer questions?
Thank you, Mr. Chair and members. It's good to see you again. My desire is just to be here and to offer any question or any answers. I also have testifiers who are available if there are questions. But in fact, Mr. Chair, that's my intent as well. And there's an amendment that's been drafted.
Yes, the A15 amendment to delete Section 2 of Senate File 2689 has been distributed to members. If you want to look in the underlying bill, you will see that Section 2 is the language from Senate File 730. It's on page 2 of the bill. Senator Oumou Verbeten moves that we adopt the A15 amendment. Is there any discussion on that? There will be a roll call. Is there any discussion on the A15 amendment? Senator Kreun.
Thank you, Mr. Chair. I'm not going to belabor the merits that we already discussed. I would just simply add that this is a bill that gives more money and more authority to the Attorney General's office, and I think it's perfectly reasonable to expect more transparency as well. So I would oppose this amendment. Thank you.
Well, for some reason, Senator Kreun, this amendment materialized out of nowhere in a different committee that has nothing to do with data practices. And so we should frankly not have to be dealing with this bill here today. But I won't try to figure out the provenance of the Human Services Committee amendment that brings the bill back to us. There's been a roll call request. Senator Kreun.
Thank you, Mr. Chair. My bill is very well known to all members in the Senate. I'm not on the Human Services Committee, and I would appreciate not even the implication of impugning whatever you're thinking happened. This is a bill that's important to a lot of members, and one of the members on that committee decided to bring that amendment.
The clerk will take
that committee passed it, and now here we are, and I oppose stripping it out.
The clerk will take the roll on the A15 amendment.
Chair Latz,
Yes.
Vice Chair Oumou Verbeten,
Yes.
Senator Limmer,
No.
Senator Clark,
Yes.
Senator Holmstrom,
No.
Senator Kreun,
No.
Senator Pappas,
Yes.
Senator Seeberger,
Yes.
Senator Westland,
Yes.
Senator Westrom.
No.
There being 6 votes in favor and 4 opposed, the amendment does prevail.
Thank you, Mr.
Now-
Chair and members.
Hold on,
Oh, I'm sorry.
because we still have your bill in front of this
Sorry
committee.
about that.
Senator Johnson, Stewart. So Senator Oumou Verbeten moves that Senate File 2689 as amended be recommended to pass and be re-referred to the Senate Committee on Finance. All those in favor say aye. Aye. Opposed? Motion prevails. All right.
Now, can I say thank you?
Now you may say thank you, Senator Johnson.
Thank
Stewart.
you.
All right. Members, we might be done by then. No, we probably won't. But we're going to take up Senate File 4248 right now. Senator Drazkowski. FYI, members, at 12:30, we are going to recess for some lunch and give members an opportunity to stretch their legs. And depending on how long this bill takes, we may do so before then rather than taking up Senate File 4997, because that's going to take some time. Oh, we also have Senator Dibble's bill here we might be able to fit in before then. All right, members, we are on Senate File 4248, Senator Drazkowski. This is the first committee of jurisdiction on this bill. To hear it, that means the amendment that's in your packet, which is a delete everything amendment, the A1, is an author's amendment, and the A3 is drafted to the A1 amendment. So we're going to treat them both as an author's amendment. Senator Kreun, a co-author, no, not a co-author.
Mr. Chair? Mr. Chair?
Senator Drazkowski.
If I could just bring your attention to A3 before it's adopted. I was reviewing this with Senator Kreun and council and others, and we may want to cross out must and make it may there. And if we can just make that editorial change before it's adopted, it might be easier.
Okay, Ms. Primo, our Senate counsel here, concurs that that's a good change. So Senator Kreun moves the A3 amendment with the change on line 3, must is deleted and replaced with the word may. Moves the A3 amendment as amended then to the A1 amendment. All those in favor say aye. Aye.
Aye.
Opposed? The motion prevails. We now have before us the A1 amendment as amended by the amended A3 amendment. This is an author's amendment. So Senator Kreun moves that. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Members, we now have in front of us the delete everything A1 amendment as amended. Senator Drazkowski, would you please tell us what your proposal does?
Mr. Chairman, could I ask a question first?
Senator Pappas.
Thank you, Mr. Chairman. I think this is very odd in that the delete all amendment has literally nothing to do with the underlying bill. So I don't think I've ever seen that before, that I'm not finding anything in here that has to do with the parent-child relationship. It appears to be a fraud bill that has to do with a tax provision. So I just want to express my surprise.
Senator Pappas, we are finding a vehicle to be able to move the tax bill forward at the request of Senator Drazkowski and the Taxes Committee Chair, Senator Rust. This language, and the intention here is to consider the language and to lay the bill over, but that way the language that does have something to do with our jurisdiction will have been considered by the Judiciary Committee, and then I anticipate it's going to find a path forward in the tax bill. Is that, Senator Drazkowski, am I anticipating the path correctly?
You are, Mr. Chair, and just for Senator Pappas and others, the bill that is represented by the A1 amendment passed out of taxes yesterday and went to general orders. And I spoke with Senator Latz about it and the data practices pieces in that bill. And the chair was kind enough to suggest that maybe what we could do is address this in committee so that you all could hear these provisions and we could get it right. So the bill still sits on general orders, but we want to do this separately and make sure that your eyes and minds get wrapped around this and get it correct today. So thank you, Mr. Chair, for that offer and for the help.
Mr. Chairman, Mr. Chairman, just one more very unusual thing we're doing this year.
Is there any discussion? Well, Senator Drazkowski, why don't you tell us what the underlying bill does and what we should be considering here?
Thank you, Mr. Chair and members. This originally was Senate File 5032, represented in the A1 amendment. It is a 100% income tax on program fraud in public programs. And the parts that are particularly the committee should look at are Section 1, Section 2, and Section 6, and then there's a reference on Subdivision 3 of Section 5. But really, maybe the meaty parts for you are the references in Section 1. Does that work for you? I had extensive help from the Department of Revenue in writing this. So Section 1 basically allows data exchange between the Financial Crimes and Fraud Division of BCA and the Department of Revenue, both ways, members, and that's what that accomplishes. Section 2 does the same thing with the Office of the Inspector General, shares data both ways, the Subdivision 3 on Section 5 is really, I think, for the department's purposes, belt and suspenders to make sure they remember what is in Section 1, is what I gather there. And kind of the same thing with Section 6. It writes it into the BCA data statutes so that it's clear there as well. And that's what we see. I guess one question of concern that I had, or question maybe for the committee, I guess as you look at the A3 amendment, are you guys okay with that language? It uses disseminate data instead of share or some other things. And then it does say any classification. Is that too broad, or should we say investigative data? Or are we okay since that data is shared between the agencies anyway, and they also have their own data sharing of or limitations on data that's shared with them by other agencies?
So we're going to have Ms. Primo respond to that, but before we do, I'm just going to note that Section 4, which is the meat of the purpose of your bill, Senator Drazkowski, because it relates to penalties for fraud. We would say that falls within this committee's jurisdiction as well. So just for members' consideration, the 100% tax on fraudulently obtained funds is within our consideration as well.
Certainly,
Ms. Primo,
Mr. Chair.
to Senator Drazkowski's inquiry relating to the breadth of the data classification in the A3 amendment.
Mr. Chair and members, that could certainly be limited. We could also identify the specific types of data. I use the term any classification to capture sort of a broader amount of data because the Inspector General bill, it's a bill right now. It has not passed. And so depending on how that language will change, with the idea that maybe it does get enacted, it may be better to have a broader classification with that in mind, because that other bill is evolving and it's unclear how it may impact various things. But if there's specific data that the committee would like to include instead of a broad classification, that's certainly a committee and bill author choice, and I can help draft that.
Senator Drazkowski. Do you have a
Mis-
preference?
Mr. Chair, I'm okay with the way the language is now, if the committee's okay with it.
Any discussion from members of the committee to that point? Any discussion from members of the committee to any other point in the bill? I'm not seeing any. Senator Drazkowski, you presented us with apparently a non-controversial bill, except for the jacket vehicle that's being used to lay it over. So Senate File 4248 is laid over. Thank you, Senator Drazkowski.
Thank you, Mr. Chair, members.
Or as amended, I should say, is laid over. All right, Senator,
We should take a recess for the next two things.
the next two bills are going to take longer than the 15 minutes we have before 12:30. So members, we're going to take a break right now. We'll take a recess. I'm going to say to the call of the chair, but we'd anticipate somewhere around 1 o'clock maybe. Is that fair? Any questions or comments before we do that?
Mr. Chairman,
Senator
were we going to add
Pappas.
the amendment? We did add the amendment? Okay, I missed it. I voted aye.
You did. You supported the phantom amendment. All right, members, we are, Mr. Newmeister, before we recess?
Just wanted to catch you after the meeting.
Okay, then let us recess. We are in recess.